Next, a Senate Judiciary Committee hearing on a 2016 law that removes some of the Drug Enforcement Agency's authority to regulate the distribution of prescription drugs. Witnesses representing law enforcement and pharmacists discuss the law's effect on opioid addiction and enforcement of drug laws. The hearing's 3 hours.
Welcome, everybody, and thank you for your attendance, particularly those who have to testify and answer questions for us, because I know you put in a lot of extra work to be ready for it. This hearing is on the oversight of a bill that has a long name called Ensuring Patient Access and Effective Drug Enforcement Act. Now, somebody's going to have a pronunciation for that acronym, but I'm not going to. I'm going to refer to it as the law or the bill. And I'm eager to hear from all of our witnesses today. Some would like to see this law repealed. Others insist that it should remain in place. I haven't made my mind up on that issue, so I'm interested in hearing both sides of the argument. This discussion is particularly important given the continuing opioid epidemic that has ravaged this country through the past several years. I do have concerns with how we got to where we are today and the discussions that we're having today. When Congress took this bill up in 2015 and 2016, there was little to no fanfare about the proposal. The basic goal of the bill seemed very modest: provide a definition for the term imminent danger. Distributors and other providers would have more clear guidance for what was required of them before DEA could issue an immediate suspension order called ISO. In this industry, an ISO can be a death sentence. From their standpoint, the clarification seemed not only fair, but a necessary step in helping figure out how to comply with the law. There was another practical concern, that of ordinary patients with legitimate needs having access or losing access to essential prescriptions if legitimate distributors were shut down. DEA understandably had some concerns about curbing their enforcement powers, but the unlimited, undefined enforcement authority needed some refinement. DEA also had litigation risk with such undefined authority. So DEA too had an interest in working towards amending the language to reduce their own risk. My understanding was that DEA provided technical assistance to both House and Senate staff for other members who were responsible for drafting the bill. In fact, DEA admitted as much in testimony before the House of Representatives October of this year. When the bill came to the Senate, it was referred to this committee. I took up the bill based in part on assurances from DEA and the Department of Justice that they agreed to the language in the final bill. We discharged the bill from committee, and we did that by unanimous vote. The bill then passed the Senate by unanimous consent. It also passed the House by unanimous consent. President Obama signed the bill into law April 2016. DEA testified that they advised President Obama to do just that. So let me be clear. If DEA or Department of Justice didn't want this bill, I wouldn't have taken it up, period. Then the Washington Post and 60 Minutes ran pieces criticizing the new law. Both stories highlighted former DEA employees and quoted a law review article from the acting chief administrative law judge for DEA. The reports in the media suggest that Congress was in the back pocket of the opioid industry and that this bill was a giveaway to the prescription drug industry. So as I've described, it should be fair to everybody to see, clear to everybody to see that nothing could be further from the truth. I've worked hard my entire career trying to combat illegal drug trafficking. My friend here from California and I have worked together on a group called the Drug Caucus to do just that, besides the work we do in this committee. And we did it to provide more effective ways for law enforcement to do their job in the drug enforcement area. I'm especially frustrated by the DEA itself, which gave Congress the go-ahead to enact this legislation. We wouldn't be here today if the DEA told us that they objected. The news reports also suggest that the law effectively stripped DEA of its enforcement power. The data appears to show otherwise. In other words, the data shows this: prior to the passage of the bill, between the years 2011 and 2015, the amount of immediate suspension orders dramatically decreased. Since the law was passed, the amount of immediate suspension orders has increased. Moreover, the number of opiates distributed overall decreased between 2016 and 2017, which all comes after passage of the bill. DEA has said that the law, quote, did not stop DEA from doing its job in the diversion space, end of quote. Even though this bill was vetted by Congress once, we all have to be open, at least I'm open, to re-examining the criticisms of the law. Hence, we're here, and I'm looking forward to the hearing what those are, in other words, what the criticisms of the law are. But we shouldn't be repealing laws just because the loudest person in the room and solely based on one person's say-so. The DEA agent who was the centerpiece of the news article is a consultant for trial lawyers who are suing the industry. So his objectivity could be questioned. The sensational news stories failed to question this conflict of interest. I look forward to hearing the testimony from the witnesses and finding new ways to strengthen our law enforcement efforts without preventing legitimate access to medications that real patients with real legal prescriptions need. Opioids continue to be a huge problem in this country. It is vital that our federal laws keep up with the best way to combat illegal opioid use. Before we start, I have a prepared statement from Congressman Tom Marino, author of this legislation, an original co-sponsor sponsor of the bill, and he introduced the House version. I have a statement from Congressman Tom Marino that I'm going to enter in the record without objection. Now, Senator Feinstein.
Thanks very much, Mr. Chairman. I'm very disappointed that neither the DEA nor the Justice Department would allow DEA Chief Administrative Law Judge Mulroney, who wrote a law review article that was critical of this law to testify. In that regard, I'm going to put in the record a letter dated December 12th from an assistant attorney general who didn't bother to sign it itself, and I can't make out the handwriting of the person who did, but essentially saying that we have other people and they will not make him available. It's the first time in 25 years I've had this kind of thing where somebody we wanted to be a witness was not permitted to come before the committee. Today we are confronted with three indisputable facts. One, we're in the midst of an opioid epidemic, the likes of which this country has never seen. Two, we have a collective responsibility to better address it. And three, clearly, law enforcement can't keep up with it. Recent news reports claim that this bill, which was enacted in 2016, is partially to blame for this struggle. The law does four things, and let me point them out. It outlines the conditions that must be met by drug manufacturers and distributors in order to obtain a DEA registration. Two, it defines what's, quote, imminent danger to the public health or safety, end quote. In doing so, it lays out the circumstances under which DEA may issue an order to show cause, an immediate suspension order, or revoke a registration. These circumstances were not previously defined, which left registrants unsure of when DEA might take action against them. This point was underscored in a 2015 GAO report, which made three recommendations to DEA about how to improve communication with registrants in order to ensure better compliance with this law. DEA has not yet implemented these recommendations. That's my understanding. Third, the law allows registrants to submit a corrective action plan prior to DEA revoking or suspending their registrations. However, it also stipulates that when an imminent danger exists, DEA may immediately suspend a registration, even if the registrant submits a correction action plan. Finally, the law required by the Department of Health and Human Services to report to Congress on how law enforcement can better collaborate with the pharmaceutical industry to increase patient access and prevent drug diversion. The department is 8 months late in submitting this report, and it has failed to respond to the inquiry the chairman and I made about it. Data provided by DEA does not seem to support the argument that this law has hindered its enforcement efforts. To the contrary, it shows that DEA enforcement actions, while now starting to increase, began declining well before this law was enacted. Between 2011 and 2016, immediate suspension orders filed against pharmacies went from 21 to 4. And those filed against practitioners went from 43 to 5. The last time an immediate suspension order was filed against a manufacturer or distributor, and this order immediately stops the distribution of pills, was, guess what? In 2012. Between 2010 and 2016, civil penalties levied against distributors dropped from $3.1 million to a mere $115,000. Sounds to me like something isn't working. So during the same years that we saw opioid overdose deaths increase by 57%, DEA's enforcement actions in many categories substantially declined. What I want to know is why. Something isn't working, it needs to be fixed. If it's not the law, and I've asked DEA and the Justice Department for their assistance in looking at the law, then we need to figure out where the problems lie. I've been struck by the examples of negligent distributors raised in recent hearings and roundtables. Let me give you an example. In a 2-year period, nearly 9 million opioids were delivered to a single pharmacy in West Virginia. 9 million pills to a single pharmacy in a small state, West Virginia. Further, between 2007 and 2012, distributors delivered 780 million oxycodone and hydrocodone pills to pharmacies throughout that state. The result? A reported $17 billion profit for distribution companies. And here's the price: 1,728 fatal overdoses over 6 years. 1,728 fatal overdoses versus a $17 billion profit for distributors. Consequently, many distributors faced and settled lawsuits with the state, yet almost all of them maintain that prescribers, pharmacies, and law enforcement are better situated than they are to prevent diversion. It's hard to imagine a circumstance under which a request for 9 million pills to a single pharmacy or 780 million pills to a single state would not set off warning bells to those distributing them. In my judgment, there was no excuse for the continued shipment of these drugs. The regulations promulgated by the Controlled Substances Act require manufacturers and distributors to conduct due diligence of their customers, to detect and disclose suspicious orders to DEA, and to keep complete and accurate records relating to the manufacture or distribution of controlled substances. It may well be that DEA needs to issue more guidance as to what constitutes a suspicious order. But these examples illustrate the fact that some distributors appeared to be more concerned with their bottom line than fulfilling their responsibilities under this law. Bottom line, we can't turn a blind eye to this kind of reckless disregard, and law enforcement must actively pursue these kinds of cases. With that, I look forward to hearing from our witnesses about how and whether this law should be modified. We cannot continue, ladies and gentlemen, to lose more than 33,000 Americans each year to an epidemic that's entirely preventable. Thank you, Mr. Chairman.
I want to associate myself with the disappointment that Senator Feinstein expressed that the witness we asked to come was denied coming by the administration. Today we sent a letter to ask reasons why, because we didn't get proper justification. Of course, now writing that letter doesn't do any good except to give us a justifiable reason if they have one, and I doubt if they do. If it's okay with my colleagues, I want to call on Senator Hatch before I introduce our witness because of his leadership on this issue. So would you proceed, Senator Hatch?
Well, thank you, Mr. Chairman, for holding this hearing, for allowing me to make a statement. Too often in this town, narrative gets ahead of facts. A newspaper prints an explosive heading, and it's off to the races. It doesn't matter what the actual facts are. The bandwagon starts rolling, and everyone wants on or off, as the case may be. Indeed, Mr. Chairman, I was both surprised and disappointed by how quickly everyone seemed to start running from this bill the moment some negative news reports came out. From Senator McCaskill to Senator Manchin to Attorney General Sessions, it seems like everyone's trying to wash their hands of it, but no one ever told me they were dubious about this bill when it was going through. No one entered a statement of opposition into the record or offered an amendment to change the bill. To the contrary, the bill passed this committee by voice vote and passed the full Senate by unanimous consent. So these last 2 months have been deeply frustrating to me, Mr. Chairman. I wish some of my colleagues would stop trying to rewrite history or pretend this was some sort of shell game. That's why I'm glad we're holding this hearing today. I want to talk about the facts of this law, the facts of my involvement and of this committee's involvement, and the facts of the law's impact. Let's start with the impetus for this law. This law came about not because I or anyone else got some giant check, but because of very real concerns that the way DEA was operating was threatening patient access. Representative Marino has said that he became involved after meeting with a community pharmacist in his district who was, quote, having so much trouble obtaining prescription opioids that he had to turn away legitimate patients, unquote. I heard similar concerns from constituents, one of whom will be testifying today, and it wasn't just Utah and Pennsylvania. Across the nation, pharmacies were facing supply chain problems. A January 2014 survey by the National Community Pharmacists Association found that 75% of respondents had experienced 3 or more problems with stopped shipments in the previous 18 months, and that a majority had to turn patients away as a result. News reports from Indiana to Florida detailed stories of legitimate patients who were having significant difficulty obtaining needed medication. No doubt these supply chain problems had multiple causes, but DEA's activities were a contributing factor. According to a 2015 GAO report, the lack of clear guidance from GEA to distributors on what constitutes a suspicious order and what can trigger an enforcement action was leading many distributors to place quotas on drug shipments to pharmacies, a practice that the report found can, quote, negatively impact patients' access, unquote. The report detailed how fear of enforcement actions coupled with lack of agency guidance was leading distributors to decline to fill orders, even in cases where a distributor had no evidence that a pharmacy or doctor was engaging in diversion. And it wasn't just a lack of guidance. I've had a number of individuals tell me that DEA's attitude toward registrants during this period was downright antagonistic. I have a letter here from a VCU professor that describes some really troubling conduct by diversion control agents, and that explains how difficult he found it to try to work with the agency in good faith. And it wasn't just the private sector that was having difficulty dealing with DEA either. In a separate 2015 report about drug shortages, GAO described the great difficulty it had in getting information from DEA's Office of Diversion Control. According to the report, completion of GAO's work, quote, was delayed significantly because of DEA's refusal to comply with GAO's request for information for over a year, unquote. Only after the intervention of, quote, senior DOJ management officials, unquote, was GAO able to obtain the data it was seeking. The Ensuring Patient Access and Effective Drug Enforcement Act was an effort to respond to these problems, to provide clearer guidance for supply chain members and to encourage greater cooperation between DEA and the requested community. That's why it defined the agency's immediate suspension order authority. And that's why it provided for corrective action plans. This wasn't some effort to help drug companies kill people. Give me a break. This was an effort to ensure that DEO's praiseworthy efforts to stem abuse don't end up hurting legitimate patients. Now, I'd like to just say a word about how this law came together. I want to be clear right at the outset that this was not a pharma bill. Don't tell me I did this bill because pharma donated however much money to me. Prior to introduction, Senator Whitehouse and I negotiated with DEA distributors and patient advocacy groups. We may have talked to a pharma company at one point or another, but they were not key players. And you know what? The bill Senator Whitehouse and I introduced, DOJ was okay with it. They said so in writing to this committee. Of course, legislation is a process, and after introduction, I thought it was necessary to make changes in order to move the bill forward. I would have preferred not to, but we all know that legislation requires compromise, and so I had to accommodate some requests from industry stakeholders at the request of other members of this committee. I negotiated these changes with DEA and DOJ. In fact, the Department of Justice gave me the substantial likelihood language that critics now seem so fixated on. And once DEA and I came to a point where we agreed on a path forward, I asked the chairman to put the bill on a markup, and I kept my end of the bargain. I told other members that what DEA had asked me to tell them, and made the floor and record statements I'd promised DEA I would make. I did all of this in good faith. I later came to find out that notwithstanding our agreement, DEA and DOJ were telling other offices they still had some concerns with the bill. For reasons I don't understand, they never shared these concerns directly with me. But evidently, the concerns were not that significant, as DEA did not try to stop the bill. As all of us on this committee know, any bill can be stopped by agency opposition. All it takes is one hold. So that's how we got here. The bill addressed a very real problem, and it did so in a carefully crafted, carefully negotiated way. If DEA has concerns with the bill, I'm happy to hear them. But I'd also ask DEA to explain why those concerns did not cause it to stop the bill 18 months ago before it became law. So with that, I thank you for allowing me to make these comments, Mr. Chairman.
Mr. Chairman.
Senator Whitehouse.
I will only speak briefly. I accept and adopt the remarks of Senator Hatch. The only thing that I would add to them is that in addition to everything that he has said, we even then built a backstop into this bill to make sure that there was no harm from it. And we gave responsibility for that backstop to a separate agency than DEA. HHS was given the legal obligation to do a report on what the result of this bill was so that we would know how to respond. They are now late and in violation of law. They have not provided that report. And I think it would be very helpful if we were having this hearing with the legally required HHS report that we demanded. I think it's fine to go ahead without it, given that they have delayed, but this would be a more productive hearing if HHS had done its job as we required. We would have better information to look at this, and in terms of the good faith of this proceeding, very clearly building in that review backstop was a strong signal that we really wanted to get this right.
Okay. I'm now going to introduce our first witness, Ms. Ashley. And then I'll swear her, and then we'll listen to her testimony, and then we'll have questions of her. She represents the U.S. Drug Enforcement Administration. Ms. Ashley is currently the acting assistant administrator for the Diversion Control Division of that agency and has worked within that agency for now over 30 years. As acting assistant administrator for DEA, Ms. Ashley oversees investigations, influences regulations, and advises national security staff, government agencies, media, and private organizations on matters related to the diversion of legally produced controlled substances. Would you please stand and let me issue an oath? Do you affirm that the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you for your assent. Now you may proceed with your testimony, and as usual, if you have a much longer testimony, it'll be placed in the record. And I never wrap the gavel at 5 minutes, but try to sum up as soon as you can after that time happens. The red button.
Chairman Grassley, Ranking Member Feinstein, and distinguished members of the committee. Thank you for the opportunity to discuss the Ensuring Patient Access and Effective Drug Enforcement Act. This legislation altered the procedures that govern the manner in which DEA seeks to revoke registration against those who whose continued authority is no longer consistent with the public interest. Sadly, over the past 17 years, our nation has been devastated by the opioid abuse, with more than 300,000 opiate-related deaths. The epidemic has created a generation of abusers, currently estimated at 12 million. While prescriptions for Schedule II opioids have begun to decline, making Schedule II opiates less accessible, Mexican drug cartels have filled the void by producing cheap heroin and counterfeit pills, often mixed with fentanyl. The results are tragic, with a record 64,000 estimated overdose deaths in 2016. I want to assure this committee that DEA uses all tools, administrative, civil, and criminal, to ensure its 1.7 million registrants comply with the law. Since 2011, DEA has revoked nearly 1,000 registrations each year through orders to show cause, immediate suspension orders, and voluntary surrenders. ISOs are used judiciously and have historically been used against those directly responsible for causing harm in the community. Doctors writing illegitimate prescriptions and pharmacies that fill those prescriptions. As someone with 30 years' experience as a diversion investigator and now as head of the DEA's Diversion Control Division, I have used all of these tools to counter the diversion of controlled prescription drugs. ISOs are not our only tool and should not be the sole metric by which DEA measures success or failure. We have also aggressively pursued civil actions designed to ensure compliance with the CSA. Over the last decade, DEA has levered nearly $390 million in fines against opioid distributors and entered into memorandums of agreement with each distributor that establish additional compliance measures to ensure that they report suspicious orders. The same distributors are now the subject of investigation by a coalition of 41 states' attorneys general. The DEA is sharing information in support of those investigations. DEA has also prioritized its criminal investigators by embedding them alongside diversion investigators in groups called tactical diversion squads. These groups are solely dedicated to investigating, disrupting, and dismantling individual organizations involved in diversion schemes. Since 2011, DEA has more than doubled the number of tactical diversion squads to our present total of 77. Last week, we announced the results of Operation Full Pharmacy. This ongoing effort targeted 26 pharmacies in California, Nevada, and Hawaii. To date, this ongoing effort has resulted in 23 arrests, $4.3 million in cash, and perhaps most importantly, for purposes of this hearing, 10 voluntary surrenders of pharmacy registrations. We are also scheduled to increase the number of tactical diversion squads to 100 by 2019. The Diversion Control Division also works closely with registrant community to educate them of their regulatory requirements under the Controlled Substances Act. We recently completed a nationwide training initiative to raise awareness on the importance of the role of that pharmacists play in filling valid prescriptions. We offered this training free of charge in all 50 states, the District of Columbia, and Puerto Rico, and trained 13,300 pharmacies and pharmacy technicians. I am happy to announce that in 2018, we will begin a similar initiative to train doctors on record keeping and other regulatory requirements. Many of our colleagues have asked, how has this legislation impacted DEA? While it has not prevented us from issuing ISOs, we have issued 9 since the bill's enactment. The new standard does make it more difficult to issue an ISO to non-compliant manufacturers and distributors. This law has changed the manner in which DEA pursues orders to show cause against registrants. The law now gives the registrant an opportunity to submit a corrective action plan. A very small percentage of registrants who have been subject of an order to show cause proceeding have submitted a corrective action plan, and none have been approved. Regardless of the legal framework in which we operate, DEA will continue to work tirelessly to combat this devastating opioid epidemic. If Congress decides to revisit this issue, then let me assure you that our agency will work with the department. We will be there to assist as we have done many times before. Thank you for your commitment to combating this epidemic, and I look forward to your questions.
Thank you, Ms. Ashley. We'll have 5 rounds of question. I'm not going to, leading into my first question, I'm not going to repeat a lot of stuff I made in my opening statement, but it kind of adds up to the fact that when this law was passed, it was not controversial. So my first question is, my understanding is that DEA is in favor of quote unquote changes to the law, but would not give Congress an answer whether DEA wants to repeal it. Does your agency have an answer to that basic question here today of whether or not you want it repealed? It seems to be a pretty simple question. Do you favor repealing the law, or do you favor amending it in some way?
I'm sorry, Senator, in collaboration with the Department of Justice, DEA and the Department of Justice we are in agreement with a change. And that change, what that change will look like ultimately, it was going to require further discussion. But what we believe now, we're leaning more toward just amending it.
Making changes?
Yes, just making changes to the existing one.
Do you agree that there was a need to change the law in the first place? Isn't that why DEA agreed to provide technical assistance to the members of Congress who drafted the bill, talking about the bill that's now law?
Sir, I'm in a difficult position here today because I wasn't present for any of those conversations, and to that measure, neither were, it was a different administration. So it's really difficult for me to try and piece together who the conversations were with and how they went about. But I can tell you here today, I can give you a feel of how it's made it harder. And that's, since its enactment, because that's when I came on board, okay. Since its enactment.
Yeah, thank you. You'll see we have a chart up here. Both Senator Feinstein and Senator Hatch has made reference to some of these figures as I did. This data was provided by DEA showing the number of immediate suspension orders, or ISOs as we call them, between the years 11 and 17. The data shows that ISOs went down dramatically each between 11 and 15. In 2011, DEA initiated 65 ISOs, and by 2015 the number was down to 5. And this all happened prior to the enactment of this legislation. My question, couple questions. Doesn't this data pretty clearly show that this particular bill had no effect on DEA's enforcement ability? And would you say, in answering that question, that the data directly contradicts the claim that, quote, Congress effectively stripped the DEA of its most potent weapon by enacting the legislation, end of quote, and that the law made it, quote, virtually impossible for DEA to freeze suspicious narcotic shipments, end of quote?
Senator, I'm careful not to conflate the two, because when we conduct investigations, we go where the evidence takes us. So we do what needs to be done is the bottom line. In those, so if an order to show cause is not warranted at the time, then that's not the direction that we go in. So I don't want to conflate the two, that the number of ISOs went down. It could have increased in another area. It could have increased. We have several tools in our toolbox. When DEA engages with a registrant, we have the responsibility to detect and prevent diversion, and we also have the responsibility to ensure that medicine gets where it's supposed to be, that access is available. So when we engage, we may have made the decision to administer a letter of admonition, or to do a memorandum of agreement, or to do an informal hearing. So again, I'm not necessarily wanting to conflate the two, because ISOs, or I'm sorry, order to show causes may have gone down, but it may have gone up in another area.
Without agreeing or disagreeing with your decision not to conflate, it seems to me that when someone else from DEA testified in the House that this bill, quote, did not stop DEA from doing its job in the diversion space, quote, end of quote. Isn't that, somebody else in the department says that, isn't that right? And he also testified that the same hearing, at that same hearing that this stated did not show that the law fueled the opioid epidemic. And isn't that right? Because that's coming from somebody in your department.
In our department, and I agree wholeheartedly that it does not stop us from doing our job. We find a way because, you know, again, as this committee, the speakers have already stated, that this is a prescription opioid, or this is an opiate epidemic, and we use every tool within our boundaries that we are authorized to use to combat this problem.
How, and this will be my last question, and I have to go to Senator Feinstein. How exactly has the DEA had to change its ISO procedures after the bill was enacted?
Senator, the way I can do that best is to provide an example. Prior to the legislation, we were able to, well, our mindset was to pursue these types of investigations from a preventative measure. And I'll give you the example, even the one that was brought up a little earlier, distributor shipping millions of dosage units of pills to a pharmacy in West Virginia. That pharmacy is responsible by law and regulation to report suspicious orders to the DEA. They are responsible to exercise due diligence to make a determination whether or not the controlled substances that they are handling, that they are accountable for it, and to make sure that basically try and prevent any diversion. So prior to the law, if there were distributors who would do these types of things, send those type of millions of dosage units to a pharmacy, not report suspicious orders, we have found in particular cases internal documentation that would state basically giving guidelines on how to circumvent DEA regulations. So prior to the law, that was enough ground for an order to show cause. Now that the law is passed, it states that it has to be a substantial likelihood of an issue, and it has to be immediate, and it has to show abuse. So if I could give you this example real quickly, I'm looking at my time here. If I could give you an example of a distributor, of a patient who has died, so we have death now, going and getting a prescription from a pharmacy, and the patient fills the prescription at the pharmacy, sells that medication, and someone dies. With the law that's in place now, I need to make a connection, a nexus between that distributor and a death versus prior to the legislation, I can do it on the prevention, on the prevention level. This is before the pill gets, I can start an immediate suspension order on the distributor before it leaks out and gets down and connects to a death. So the legislation now states that there must be death, serious bodily harm, or abuse. Prior to that, it was diversion.
Okay. Senator Feinstein, and then I'm going to step out for a minute, and after her time's up, Senator Hatch, if I don't get back, but I think I'll be back.
Thanks, Mr. Chairman. I am looking at the DEA immediate suspension orders from 2008 to 2017. And in 2011, there were 65. In 2017, there were 6. In 2015, where I pointed out 33,000 people died of overdoses, there were 5. I look at the aggregate production quotas, and there are 4 criteria. These factors do not include trends of abuse or overdose death rates for specific classes of drugs. They should. I mean, how do we keep functioning and let this happen?
Senator, if I could answer the question in 2 parts. First, addressing the immediate suspension orders. I'll go back to investigators going where the evidence takes us. If immediate suspension order is warranted, then that's where we pursue the investigation. And if, in speaking to the quotas, the difference is, I'm sorry, Senator, your question in the beginning regarding the quotas.
Well, the quotas don't include trends of abuse or overdose death rates for specific classes of drugs. Why not?
I recall. So that's something we have to be very careful about. As I mentioned, we want to prevent and detect diversion, and we have to ensure an adequate supply. So as far as in making the determination of the trends, we are bound by statute when we determine what the aggregate quota is going to be. We're bound by statute, so some things have to be there. I would need to take back to our quota section and to our office and have a more lengthier discussion how that type of thing can be added into, what the statute already exists.
Let me say something. I just take this with the greatest sense of alarm that we have all these deaths going on and nothing changes. And
if I can say,
I think your answer is really not a good answer. I mean, every alarm signal is out. People are dying by the tens of thousands.
Yes, Senator.
And yet the shipments go on. And DEA, in my view, is not doing its job.
Senator, if I could respond to that, again, we are bound by statute when it comes to quota, but there is something that we can do on that subject. If the DEA can determine that a specific manufacturer's product has been tied to the proliferation of drugs in one community
How about
or
the West
death.
Virginia case of small pharmacies?
Exactly. In that type of circumstance, what can happen is, now this is after one specific drug is identified, one specific manufacturer's drug is identified, we can decrease their quota. But I hear you, Senator, and I understand, and I'd very much like to take that back and continue to work with your committee.
So in other words, presently, a small pharmacy can receive millions of pills and nothing happens.
That's not the way it should work, Senator.
Well, it's working that way. You just said that was the way it works.
Senator, what a distributor is responsible to do is exercise due diligence. They are responsible to have great care and accountability over the shipments that they send out, and that's where DEA comes in with the oversight and the regulatory controls.
Well, when 33,000 people die in a year from overdoses, maybe a few distributors should be shut down. That's exactly the way I feel.
I hear you,
and I think this whole view of business as usual is just not working. So the administration really becomes liable for not making the changes that are necessary to prevent these overdose deaths from happening. And I've never said this before. I've been on this committee for a long time, but I have never seen a more lax operation. And I can't help but say that. And when people die because of it, you get really angry. Thank you.
You bet. Senator Hatch.
Well, thank you. Before I begin, Mr. Chairman, before I begin, I'd like to ask if we can do a second round of questions with this witness after everyone else has had their opportunity to go.
I think we'll have time for that.
Okay.
I'll make a judgment after we see how many members come, but the way it is right now, I think we can.
Okay. As you can imagine, I have a number of questions for her. Now, I'd like to start, Ms. Ashley, by talking about immediate suspension orders, or ISOs. There have been a lot of allegations that the Ensuring Patient Access Act gutted DEA's ability to issue ISOs and caused enforcement actions to plummet. So let's look at the actual data. I have a chart here, right here, of ISOs issued by DEA over the last 10 years. This data comes from DEA. I've given you a copy to refer to, and you'll see that ISOs start off in low double digits in 2008, peak in 2011, decline until around 2014, and then stabilize thereafter. The vertical dotted line represents when the Ensuring Patient Access Act was passed. Now, Mrs. Ashley, when you look at this chart, which shows that the decline in ISOs began 4 years before the Insuring Patient Access Act passed, is there any conceivable way that the act could have caused the decline in ISOs?
Senator, this is a tool for immediate suspension orders that DEA has historically used sparingly. Again, we move forward with where the evidence takes us. Now, they've been used sparingly, but they've also been used for the most part, predominantly for physicians and also for pharmacies. It's a difficult challenge to connect a distributor and immediate.
Yeah, but I was asking for a yes or no answer.
Has it changed?
No.
Has it impacted our ability to issue ISOs? No, sir, it has not.
In fact, you'll note that DEA issued more ISOs in 2017, the year before the act passed, than it did in 2015, the year before it passed. I'd also direct your attention to the short orange bars on the chart. These represent ISOs against distributors and manufacturers. The blue bars are total ISOs, and the orange bars are ISOs against distributors and manufacturers. ISOs against distributors and manufacturers have been a particular focus of news reports criticizing the bill. Now, these reports have described these ISOs as DEA's most effective tool against large drug companies. Now, there's actually, looking at the chart, when the Insuring Patient Access Act passed in April 2016, how many years had it been since DEA had issued an ISO against a distributor or manufacturer?
The last one was 2012, sir.
I'm sorry, I didn't hear you.
The last one was 2012, sir.
Oh, okay. In fact, it had been just under 3.5 years, as I see it. So not only could this law not possibly have caused a decline in ISOs, but at the same time the law passed, it had been over 3 years since DEA had issued an ISO against a distributor or manufacturer. Simply put, the notion that ISOs against distributors and manufacturers were a critical and frequently used tool before the Insuring Patient Access Act passed, and that the act caused DEA's use of the tool to dry up, is simply not correct. Would you agree?
Oh.
Yeah, I do agree, sir, but
Okay, that's all in fact, over the last decade, the most ISOs against distributors or manufacturers that DEA ever issued in a single year was 3. Now, there's also been criticism of the Act's requirement that DEA notify companies of the ability to submit a corrective action when issuing a show cause order. Judge Mulroney, in fact, used some strangely intemperate language in his article in describing this provision, saying it was akin to allowing bank robbers to round up and return ink-stained money and agree not to rob any more banks. Now, I have to say that's a bit much. The purpose of this provision was to encourage greater cooperation between DEA and supply chain members. It was also to avoid the situation some doctors and pharmacists were facing, in which DEA ALJs would not allow them to present any evidence of corrective action unless they first accepted responsibility for all of the conduct DEA had alleged, even if the doctor or pharmacy had not committed all of the alleged conduct. And just to clarify, the corrective action plan provision applies only to show cause orders. There's no requirement in the Act that DEA provide an opportunity to submit a corrective action plan before issuing an ISO. The suggestions to the contrary are incorrect. Now, I do have another chart. I guess I'll have to wait till I...
Yeah, I'd like to continue. Senator Leahy.
Well, thank you, Mr. Chairman. This is troubling. Obviously, DEA or someone totally dropped the ball in West Virginia. Deaths occurred. The people selling the drugs made a lot of money. they knew they were selling far, far more than there could conceivably be a need for medicinal purposes. And while the legislation we're talking about passed House and Senate, nobody at DEA opposed it when asked. So the whole thing is so murky, it seems the people selling the pharmaceuticals are about the only ones who are coming out well in all this. Now, there's been a lot of discussion regarding the startling drop in DEA's use of immediate suspension orders, but ISOs don't capture all the story. There were that same period when they went from 65 in 2011 to under 10 in 2010. I understand there were a number of voluntary surrenders, as many as 1,000 a year. Is that correct?
Yes, sir.
And cannot a voluntary surrender be a quiet resolution to any serious criminal investigation?
It is a resolution, and it's a great tool for us, sir.
But it also, for the person who's surrendering, avoids having to face any criminal charges. Is that correct?
So with the order to show cause in the ISO, there would not be criminal charges, sir, but it is an administrative action, would immediately stop the registrant's ability to handle controlled substances. So it is a great tool for us.
But they don't have any penalty or public admonishment. But somebody else can just step in and start doing exactly the same thing. Is that correct?
Well, yes, sir, that is correct.
No, as a former prosecutor, I tend to think of sometimes criminal action as being a deterrent. And if you have 1,000 of these with non-criminal action a year, is that really working much as a deterrent in your estimation?
It is a deterrent, sir, because one thing we have to keep in mind is we have 1.7 million DEA registrants, and the overwhelming majority are doing things the right way. So there's that very small percentage that may be violators, bad actors of the Controlled Substances Act, and they are, a tight-knit community, as most professionals are, and when they're in the same business activity. And yeah, I believe, in my experience, it does create a deterrent effect.
They're supposed to have if they're registered with DEA, they're subject to unannounced regulatory investigation every 2 years. And have these been effective? Has anybody evaluated these investigations?
Yes, sir. And right now, actually, we have a working committee to basically revamp our scheduled investigations. That for the different business activities, there are different types of different periods of time when investigators would go on site and conduct those investigations.
The reason I ask this, we've asked questions. For example, Senator Wyden and I sent a letter to DOJ, DEA regarding diversion enforcement. We did this in 2016, especially after there'd been an article in the Washington Post saying there was a coziness in the DEA diversion enforcement actions because of coziness with the wholesale drug distributors. We finally got a response. It didn't answer the questions. Would you look at that 2016 letter and respond to us?
Yes, sir.
You said that DEA stated is working to provide specific guidance to registrants regarding the identification and reporting of suspicious orders. That's a year ago. When will we see that guidance?
Sir, we're in the final stages of that, and I anticipate it'll be spring. And actually, in the spring, we also have a meeting with stakeholder registrants to have a discussion about it.
In that, are you being affected at all by President Trump saying that if you're going to have a regulation, you got to get rid of 2 former regulations?
Certainly, we have to be in compliance with the acts that are in place. Certainly, we have to be in compliance with that. So, but that doesn't prevent us from continuing to draft regulations.
Okay, thank you. Mr. Chairman, I think under those circumstances, if I was going to be involved in criminal activity, I would love that order of 1 step forward, 2 steps back. But I thank you for your commitment to get that, finally getting us an answer to that letter, and I'll look forward to it.
Absolutely, sir.
Thank you, Mr. Chairman. Ms. Ashley, welcome. How long have you been with DEA?
Over 30 years, sir.
Okay. And you're the acting assistant commissioner or administrator?
Yes, sir.
Does that mean you're the number 2?
No, I'd say I'm 3 down, but and then I go lateral.
You're within the top 5, huh?
Top 9?
Top 5?
Top 9, sir.
Top 9, okay. What was your position under President Obama?
For a period of time, I was the deputy assistant administrator, and prior to that, I was diversion program manager in the Chicago Field Division.
Okay. So you were a senior official?
Yes, sir.
What was your opinion at the time about the Ensuring Patient Access and Effective Drug Enforcement Act?
So if I can clarify, sir, I reported basically under the end of President Obama's administration in October of 2015. So by the time I reported, all those conversations had already passed, and it was down the road.
I appreciate that clarification. You were aware of this act?
Yes, sir.
When it was a bill?
Yes, sir.
Were you for it or against it?
I was concerned about it, sir.
And to whom did you express those concerns?
It was internally to my staff.
Okay. Did you express your concerns to anybody senior?
At the time, it would have been my immediate boss, who is no longer with DEA.
Did you tell your immediate boss you had concerns about it?
Yes, sir, but at the time, if I could explain, we had all just reported. It was just a new sweep in management. So he was, had just begun familiar with the bill, too. So he was not part of those conversations.
Among the top 10 people at that time, when this act was a bill, among the top 10 people at DEA, who opposed this bill?
Sir, I could name names, but none of those individuals are currently at DEA.
Okay, name names.
The prior Deputy Assistant Administrator, Mr. Joseph Renazizi.
He opposed it or was for it?
He opposed it.
Okay, who else?
It would have been his management staff.
I'd like some names if you could.
Immediately under him, he had a deputy, and I would be not precise on their time frames or when they were sitting in that chair, but there was a time where he had a deputy assistant administrator. His name was Alan Santos at the time.
Okay, who else opposed it?
The administrator at the time would have been Michelle Linhart.
Who else opposed it?
That's all I can think of now, sir.
All right, when you think of others, could you write me?
Sure, sir.
All right, who among the top 10 managers at DEA at the time, who supported it?
I wasn't present, so it'd be difficult for me to say who did support it. No,
who did you hear?
I didn't have a conversation with anyone that told me they supported the bill.
Okay, so nobody did, and you were seen.
Sir, I'm saying I didn't have a conversation with it. It's not that that no one did. I'm not aware of it, is what I'm saying.
Well, somebody had to.
I believe you're correct, sir. What I'm saying is I wouldn't know that. I had conversations with those who had.
Well, who would know that?
I'm trying to think of someone who is currently at DEA that would have been part of those conversations. Currently, our acting administrator was not part of those conversations. Myself, and my direct I directly report to the principal deputy administrator. He was not part of those conversations.
And I appreciate it, but,
I'm sorry.
you know, we're limited on time.
Yeah.
Tell me who at DEA pushed this bill at the time.
Sir, I don't have a name for you, but I would like to get back with you if I can make those determinations. I'd like to do that.
Well, see, here's what it looks like to me, Ms. Ashley, and I know Senator Hatch and Senator Whitehouse, and I don't believe that for a second that they would support legislation over DEA's objection that would hurt people. I don't believe they would do that. I think DEA or somebody at DEA said this was a good piece of legislation, and now all of a sudden we can't find them with a map or a search party. And I just want to know who did. And if everybody was so opposed to it at DEA, why weren't they raising all manner of hell?
That she'll, when she has a chance to think about answering your question, she can answer it in writing for you.
You want me to shut up now, Mr. Chairman? I was on a roll.
Well, we're going to have a second round, so you get another chance.
I'll take that as a yes and apologize for going over. Thank you, Ms. Ashley.
Senator Durbin.
Thanks, Mr. Chairman. Ms. Ashley, thanks for being here. I guess it came as a shock to me when there was testimony a couple of years ago in this very room by the acting administrator of the Drug Enforcement Administration, Senator Kennedy. I learned something I didn't know, and it's the education of a senator is a daunting task. And what I learned was that there was a federal agency which controlled the amount of opioid pills, the number, the volume, each year. They established quotas, and they told pharmaceutical companies across America, these are how many you can produce. It turns out that for a long period of time, the pharmaceutical companies have been demanding more and more and more. I've got a chart here that shows a couple of the most popular of the opioid pills, what happened to the production of them. And in order to hit these levels of production for hydrocodone and oxycodone, they needed the permission and authority of the agency that you work for. The Drug Enforcement Administration came to us and testified about the terrible opioid crisis, and then when I pinned them on it, it turns out they were given the green light for the production of the opioid pills. And pharma in general, was asking for more and more and more and more. And I said to the head of DEA, I think you're part of the problem. He said, yes, we are part of the problem. So what we're talking about here is a unique situation where the Drug Enforcement Administration is telling America how to get drugs out of America in one office, and in another office is given permission for pharma to make more drugs. Currently, we produce 14 billion opioid pills a year. Enough for every adult in America to have a 1-month prescription. Now, I know there are people with chronic pain and illness who need it, and I will fight for their right to get it. But a 1-month prescription for every one of us in this room and every adult in America? Come on, as they say in one of those sports shows. And you also, I think what brings us here today is a question about distribution. I represent, and I know pretty well, a county called Madison County in Illinois. 2014, 14.4 million oxycodone and hydrocodone pills sold in Madison County, Illinois. That's 54 pills for every resident of Madison County, Illinois. West Virginia, a single pharmacy in a town with a population of 392 people, received 9 million hydrocodone pills over 2 years. Population 392, 9 million pills. Who's the cop on the beat? Drug Enforcement Administration. And the question is whether or not we did anything to make your job easier or harder. I've watched that 60 Minutes segment a couple times. I couldn't agree with Senator Kennedy more when it comes to my colleagues. I don't believe for 1 second either one of them or any of us who were voting for this felt that we were making it easier for people to distribute an indefensible level of these drugs, but it happened. And I guess the question that we're basically asking you is, now that 44 attorney generals say we made a mistake, did we make a mistake? Should we repeal the Ensuring Patient Access and Effective Drug Enforcement Act to make sure that you have more tools and you can get tougher with those who are clearly abusing the production and distribution of these pills?
Thank you for the question, Senator. Again, we have tools, and we have a bucket of tools, and the immediate suspensions order is just one of them. We have not been hamstringed in a manner that we cannot continue to do our jobs. We look forward to working to this committee if the committee decides that there should be something differently done with the current legislation, but we'll continue to work within those bounds.
So let me see here. The DEA issued suspension orders, 65 in the year 2011, and this was in the earliest stages of our opioid crisis, 5 in 2015, 9 in 2016. I think the cops on the beat are not spending time looking for criminals here. If we are truly dealing with an opioid epidemic, with numbers that I've just read to you, these suspension orders don't match up to that rhetoric. Don't tell me this is killing Americans right and left. Almost 2,000 last year in my home state of Illinois. And then tell me that 9 suspension orders in the year 2016 shows that you have all the tools you need. I don't buy it. I don't buy it at all. Either you're not doing your job or you don't have the authority to do your job. And I'm speaking generically as an agency, not about you personally. And that's what I worry about.
Senator, this is just one tool. Certainly, we're using other tools to do our job. And we have, a dedicated workforce, as I'm sure. I've met with you a couple of times and had that discussion about quota. And yes, it did rise over several years under, prior management at the time. It was Deputy Administrator Joseph Renazizi, and as quota is determined by our statute, I don't know what he had in front of him to make those determinations. And I'm sure they were very, very careful determinations. But when I met with you, sir, we had discussions, and we went back to the table. I met with you and with also our previous administrator, Chuck Rosenberg. We went back to the table. We had discussions, and we have lowered it. The first year.
I'll just close, Mr. Chairman. We're not dealing with a runaway virus here. We're not dealing with Ebola. We're dealing with decisions made by people working in your agency and others in terms of the volume of production in America that has led to this epidemic and the abuse of that production in distribution by doctors and pharmacies and others, and our failure to respond adequately. That's why we're sitting here today.
Senator Cruz.
Thank you, Mr. Chairman. Ms. Ashley, thank you for being here and testifying. I want to follow up on some of the questions that Senator Kennedy asked you, and just, you're here testifying on behalf of the DEA. Did the DEA as an agency take a position when this legislation was pending before Congress?
I hate to keep repeating myself. I was not present during those conversations, but it's my understanding, yes, concern was expressed the entire time.
Okay. Your personal knowledge, you're testifying on behalf of an agency.
Yes, sir.
So presumably, somebody at the DEA knows whether the DEA took a position on this piece of legislation.
Yes, sir.
The agency as a whole has a collective memory. If you weren't involved in that, fine, but the agency knows.
Yes, sir.
How would that position have been expressed?
I believe that it was expressed in discussions through the department and initially working with the House and also with the Senate Judiciary committees.
Did the Department of Justice express a position on this legislation?
I believe that, yes, sir.
Did they support this legislation?
In the end, they support the ultimate language. I believe the concern of how the bill would affect how we conduct our investigations was expressed throughout.
I just want to understand. So the Department of Justice supported the legislation in the version that actually passed. Is that correct?
Yes, sir.
And the DEA supported the legislation in the version that actually passed?
Yes, sir.
What advice did the DEA and the Department of Justice give President Obama on whether to sign this legislation?
That conversation would have been through the Department of Justice. I'm not certain what it was, but I know that technical assistance was provided on the final language.
All right. So is the legislation working? Set aside whether DEA and DOJ and the entire U.S. executive branch was supporting the legislation. Set that aside. We're here now. We're a year into it. Is it working, or are there unintended consequences?
We were able to continue to issue ISOs as we have in the past, so it didn't hamstring us from doing that. The concern was manufacturers and distributors, the ability to use it, and we have not executed one since enactment of the legislation, so that remains to be seen, proving that case under the new legislation.
You say you haven't executed one. Is that a problem? Is that a lack of legal authority? Why haven't you? What are we missing?
Actually, sir, the distributors and manufacturers that we were looking at that were doing the most shipment of drugs had recent actions taken against them, and the other distributors, they're a close enough knit community. A deterrent effect kicks in but the larger distributors, the big three we call them, they had recent action taken against them. So since the implementation of the ISO, they're already under memorandum of agreement to be in compliance with the Controlled Substances Act. So it hasn't been warranted so far.
So if I'm understanding you, there hasn't been a factual predicate, there hasn't been a need for it. Is that correct?
There hasn't been a test case, sir. No.
What is not working about this legislation, if anything? This Congress is trying to understand if legislation was enacted that made things worse. We would like to know that, but y'all are on the front lines dealing with it, and we need your expert judgment to help us in assessing that.
So the concern now, prior to the legislation, we were in a preventative mode. We want to stop this distributor from making shipments before there's harm done. So we could identify violations of the Controlled Substance Act solely that the distributor committed. The current legislation requires that we establish a substantial likelihood of immediate death, bodily harm, and abuse. Prior to that, we would only need to establish the increased potential for diversion.
Does the DEA believe this legislation needs to change?
DEA, along with the Department of Justice, supports a change in the legislation, yes.
What change does the DEA support?
Now, so there's where I have to be careful. I'm not an attorney, sir, so I don't want to throw out language, the potential for language that could make it worse. But I'm happy to continue, as we have many times, work with this committee to hammer out language.
I'm going to ask you if the DEA, as an agency, has a position supporting a change in legislation. I would ask that you convey that to me, and I'm sure my colleagues would be interested in writing.
Yes, sir.
The specific language that you believe would work better.
Yes, sir.
We can't understand what you're requesting if the agency doesn't request it clearly and with language attached.
Yes, sir. I will do that.
Thank you, Ms. Ashley.
Senator Whitehouse.
Yeah, to follow up on Senator Cruz's point, we had these conversations with DEA when this bill was being developed, and we reached an agreement that DEA signed off on that was approved by the administrator, that was approved by the Attorney General of the United States, and on the recommendation of the Attorney General of the United States, was signed into law by the President of the United States. So forgive me for just a bit of frustration when we are now in a situation in which the executive branch, in the form of HHS, which is to be advised by you all at DEA, is under a legal obligation to do an analysis of what changes are needed in this bill and has refused to do so, despite being required to by law. And we have the testimony now of your agency that you have no proposal, despite a recommendation that there be a change. That's a little tough for us to work with. We are happy to try to do this and to try to make sure we get it right. But at the moment, the state of the record is that DEA signed off on the bill as it is. DEA has no proposal to change it, and HHS refuses to do the report that Congress commanded. That doesn't give us a great position. So I hope that in whatever way you can try to get these basic questions answered so we can proceed. Now, your testimony has been that you have a bucket of tools and that you have not been hamstrung by this piece of legislation because you have that bucket of tools. So let me take a minute and just go through that bucket of tools and make sure that I'm not missing any. One is letters of admonition. You can do letters of admonition more or less unilaterally, can you not?
Yes, sir.
And the second is you can call administrative hearings, and you can drag a distributor in to answer for their conduct, can you not?
Yes, sir, and those would be informal hearings.
Yes. And you can require a memorandum of understanding to be entered into by a registrant as a resolution of a dispute with DEA, correct?
That is correct, sir.
And you can even demand voluntary surrender of the license so that they have to just give it up and cash in and go away.
Yes, sir.
You can go to court if a registrant is recalcitrant and get an administrative law judge of yours to issue an order to show cause requiring them to defend their license, correct?
Yes, sir.
And that puts immense pressure on them, even the threat of that, to come into compliance.
Yes, sir.
And the ability to push for that order to show cause is unilateral on your part.
Yes, providing evidence, yes, sir.
Yes. And you can bring civil penalties, civil action. You can take DOJ lawyers and go into court against them.
Yes, sir.
And indeed, in 2017, you hit a record for $194 million in civil penalties against distributors, correct? Well, I'm not going to hold you to the number, but let's say pursuing civil penalties is and has been an effective enforcement technique against diversion.
Yes, sir.
Okay. And then finally, criminal actions. My information is that you make about 1,500 diversion cases a year in the criminal courts, in which you have the requisite intent to show and somebody actually is sanctioned, goes to jail, gets a criminal fine levied against them for all of that.
Yes, sir.
1,500 per year.
That's average, sir.
So if you have that kind of authority, then in the context, the last time you did an ISO of a distributor manufacturer was back in 2012, correct?
Yes, sir.
And let's just say you were hesitant in 2015, the agency, because the bill was coming up in 2016. But so let's go back 2 whole years to 2014. You only did 8 ISOs in that whole year compared to 1,500 criminal cases, correct?
Yes, sir.
So it doesn't sound like it's a centerpiece of your enforcement bucket of tools.
Sir, if I could say that most of the ISOs and also orders to show cause are on physicians and pharmacy. Historically, they've been used very sparingly on distributors and manufacturers.
And there's a pretty good reason for that, because usually distributors, let's focus on distributors, because that was the purpose of this legislation. Usually distributors aren't a factor, really, in the direct diversion of pills, unless you find that they have lost control of their inventory and are slipping stuff out to the public. What they're doing, mostly in these cases, as I understand it, is failing to report to DEA where drugs are going in inexplicable numbers. I mean, how often do you see a diversion case where the opioid pills are directly leaving a distributor into the hands of the illicit user?
It doesn't, sir. But what happens is the distributor is responsible to exercise due diligence.
Yes. So it's a reporting and due diligence requirement, not a direct diversion issue, correct?
Yes, sir, it leads to.
Yes.
And it increases the potential.
Absolutely.
Yes.
On the part of the pharmacy, on the part of the doctor
Yes,
pill
sir.
mill, on the part of whatever's happening downstream where the opioid pill meets the illicit consumer.
Exactly. And this is where that legislation
Great. So we look forward to,
concern.
if you have recommendations, we're eager to hear them. But I will conclude by saying it's incredibly frustrating to have the agency that signed off on this and supported it all the way through to the President of the United States now saying that it needs a change, but it's unable to articulate what that change is. And at the same time, the parallel agency, HHS, which is under legal obligation to report to us on how this is working and what we should do, refuses to comply with the law and provide the report that we've asked for. So we will continue to make these inquiries. We really want to get this right.
Thank you, sir.
And thank you for your service.
If they refuse to do it, as opposed to not having it done yet, I would be willing to follow up with you on that, because if we pass a law saying they ought to make a report, they ought to make the report.
Yeah, and the law has a date in it. They haven't had the date.
Are you saying they're actually never going to do the report? Is that what
I have no idea. They're eight or 10 months late right now. I don't.
Okay.
And there's no sign of it on the horizon. So it would be great if it was done timely, but
okay.
I think what's important is that we have the report that the law commands.
Senator Klobuchar.
It would be nice if it happened in the time frame that the law commanded.
Senator Klobuchar.
Thank you, Mr. Chairman. Ms. Ashley, I've long worked on these issues, including passing one of our first drug take-back laws with Senator Cornyn, and that's why I'm just so disheartened by what's been happening. I am a co-sponsor of the bill to repeal the 2016 Ensuring Patient Access and Effective Drug Enforcement Act. And I guess I'd start with this. Do you have reason to believe that the DEA would have issued more ISOs had the law not been enacted?
That's difficult to answer, Senator. I don't believe so. And the reason I don't believe so is because when we conduct investigations, we just take them where the evidence takes us. So that would be.
There was just happened to be a drop-off of these, while the opioid crisis was growing, there was a.
For immediate suspensions orders against, if you're speaking specifically about distributors, they've always been used very sparingly. It's almost a unique thing.
So let's go back at the numbers. I understand that between fiscal years 09 and 12, the DEA issued an average of more than 40 immediate suspension orders a year. These orders enable the DEA to stop these suspicious shipments. However, since fiscal year 2014, the DEA has averaged only 7 ISOs a year. Is that right?
In 2014.
Since 2014.
Since 2014. Yes.
Okay. And I understand that there has not been an ISO issued for a distributor or manufacturer of opioid medications since 2012. Is there a reason why only pharmacies and practitioners have been the subject of the most recent ISOs?
I can explain that when investigators engage with distributors and manufacturers specifically, because we have the responsibility to make sure that patients have access. We want to keep them in business. We want to bring them into compliance. It's only the most egregious that we would ever use in order to an immediate suspensions order for.
So there were no distributors or manufacturers since 2012 that you felt that the agency felt they should go after?
We have engaged, but we may have used a different tool.
Okay.
As Senator Whitehouse mentioned, there's so many other things that we can do to bring them into compliance.
I also understand that in addition to the immediate suspension orders, as Senator Whitehouse mentions, the DEA has other authorities through which they can revoke the registration of a drug company. Can you elaborate on this and the role of the immediate suspension order in DEA's enforcement efforts?
So the immediate suspensions order is a tool that DEA would use, and when we're on site, reveal information that there's something really egregious going on. Egregious in the sense that we would need to stop. It's not in the public interest for you to have a registration, and that this needs to cease immediately. So it's almost a cease and desist, but there's still a process behind it. Drafted, there's still the opportunity for a hearing, there's still negotiations and conversations with the prosecutors and defense attorneys. So it's still a process. It doesn't happen immediately, as the word says, but it's always been used sparingly.
Although much attention is focused on the changes to the 2016 law, certainly at this hearing, I'm also interested in hearing your views on another provision of the law which allows drug companies the opportunity to submit corrective action plans to the DEA prior to having their license revoked. What is the DEA's position on this provision of the 2016 law, and how frequently has it been used in the past year?
So our position on it is, it's just something, it's redundant and unnecessary. And the reason is, when we engage with registrants, we're having those conversations. The opportunity for mitigation and remedy have already occurred. We always try to bring a registrant into compliance. So we have that conversation sometimes for several months. So by the time we get to the point of issuing an order to show cause and a corrective action plan, we've already had the conversation. So that's why they're unnecessary.
I also understand that the DEA issued more than $194 million in civil penalties in 2017. That's more than the civil penalties in the past 7 years combined. Can you lastly tell me about this recent increase and why the DEA has been pursuing more civil penalties?
Actually, Senator, that wasn't more registrants. One registrant paid a fine of $150 million,
So
and then a second one paid an additional fine.
You think there's others out there that should be paying that kind of money?
If it warrants it, yes. As investigators are on site and identifying those type, disclosing evidence that supports it, absolutely.
It just seems odd you'd have one that would account for so much of it, that there must be others out there.
There are 3 distributors that basically supply most of the market when it for opiate drugs. So.
And what are the other 2? Are the other 2 paid?
The other 2 are other cases against them and other types of actions.
And are those pending right now?
One of them is, one is not.
Okay.
Senator Blumenthal.
Thanks, Mr. Chairman. A lot of the discussion today seems to come down to unintended consequences of this law. And one of the chief unintended consequences seems to involve the term substantial likelihood. Would you agree?
Yes, and also the word immediate and also death. Bodily harm and
I
abuse.
was going to come to those.
Oh, I'm sorry, sir.
Those issues as well. I thank you for pointing them out. Under the law that we're here to discuss, the DEA can shut down drug shipments immediately whenever it concludes that there is a quote-unquote substantial likelihood that failure to do so will result in some harm, including the harm of illegal drug abuse or other kinds of harms. I wonder if you could give us an idea of how the DEA defines the term substantial likelihood, and also some examples of situations where the DEA would want to shut down drug shipments, but it does not believe that there is a substantial likelihood. Some real-world experience as to what the definition of the term is and how it has, in effect, diminished your ability to stop these shipments.
That's one of them.
So the mission of a diversion investigator is to detect and prevent diversion while at the same time ensuring access to those that need it. So what the statute did is take away the prevention piece of it. So what we would want to do with an immediate suspension order is to stop the shipments, take away the DEA registration, so no further shipments can go, therefore preventing the harm.
But it didn't really take away that power, just change the standard, correct?
It changed the standard, yes, sir.
So you can still do it, you just have to meet a different standard. My question to you is, how in practical terms? Give me some examples. You faced a situation where,
I faced a situation where a distributor willfully, with great knowledge, avoiding the Controlled Substances Act, not reporting suspicious orders, not exercising due diligence, constructing shipments, structuring shipments so that they can remain under DEA's radar. For that, those would be grounds alone, solely, to do an immediate suspension order. With the new legislation, I would need to go upstream from the harm, and that's a death or bodily harm or abuse. I would need to work backwards.
and show a substantial likelihood of some harm.
Yes.
But you had to show some likelihood before.
We were aiming to prevent diversion because it's foreseeable if drugs are diverted and they get to someone who should not have them, it's foreseeable that there will be harm. So we always use the tool as a preventive method.
Are those shippers who were stopped likely to have had violations previously?
Likely. It's possible, yes, sir.
My guess is that the distributors who would be shut down were repeat offenders. correct?
In most cases, there's an elevation. Yes, sir.
So wouldn't you be able to use this law in light of that pattern to show the harm previously resulting from their violation?
This law, ultimately, yes, and we will. This is the law of the land, right? So DEA is going to continue to work within, what we have. We're going to continue to use the resources. So if that's what's necessary, absolutely we're going to do it. But what we would like to do is continue using use the legislation as it previously was to prevent.
You want to go back to the legislation as it existed previously with the lower bar or standard?
With the standard in which we can prevent diversion.
And let me ask you, in the short time I have remaining, should Congress be providing more funding for this kind of effort? Isn't that as big an obstacle to you in terms of diversion control and prevention, as you rightly highlighted, as this legal standard is and the change in the legal standards?
Additional resources, sir, and additional tools is always a great thing to support law enforcement. I appreciate that.
If Congress could do one thing to crack down on illegal diversion, which would you recommend? More funding or a change in this law?
That's a tough question.
Well, if it's a tough question, I gather...
Because I'd like both.
Funding is as important as a change in this law.
It is. Yes, sir.
Thanks, Mr. Chairman.
Thank you, Mr. Chairman. Obviously, if we need to make changes to this law, as you have testified, we need to know what specific changes we need to make. And in addition, Mr. Chairman, if you could go after HHS for producing the report that they're supposed to have produced. Senator Whitehouse has gone through a list of other tools that you have testified, because we've been focusing on the number of ISOs, and that number seems to be decreasing, but you testified that there are other tools such as criminal actions, et cetera. So has there been a dramatic increase in DEA's use of these other tools over a course of time that you can provide to us?
A dramatic increase.
An increase, because you say that ISOs are going down, and so there are other tools. 1,500 criminal cases, I don't know, compared to when. This sounds like you're going in the right direction, but how does that number of criminal cases, for example, which is another tool, how does that compare over time to the number of criminal cases that DEA has brought? So that's what I'm going after.
What we do is expand and grow in strategies and techniques. So there are several of them. I would actually need to get back with you to really demonstrate it, because there's so many of them that I can tell you, yeah, we have more LOAs,
so
more
MOAs. Is it your sense, or you may not have the actual numbers or percentage increase of the use of these other tools, but is it your sense that DEA has increased the use of these other tools because we do have an ongoing and growing opioid crisis in our country? Okay, so please provide us with some kind of information along those lines.
Yes.
And then I'm interested in this chart that was provided to us by Senator Durbin. And that's this chart that he had. And it looks as though there is a decreased number of requests from manufacturers for increased drug production. So did you say that this is is this just a temporary decrease? Because up to 2017, there was a pretty high approval rate. So what's going on here that leads to this lower drug production in 2017 and 18?
So, Senator, we're bound by statute when we develop the aggregate production quota, and every year we start over fresh and make that determination based on the facts that we have before us, what the United States needs, medical and scientific need, and all types of factors, inventory and that sort of thing. We met with Senator Durbin actually a couple of times and had these conversations with some other senators present. And in making those analyses, we determined, and for the 2017 APQ, that it was possible to reduce it. And that was That was actually an easy one because it was a cushion that was put on for emergency purposes only. But then for the 2018 aggregate production quota, we were able to reduce it again. And that's, again, looking at what's required by statute and doing some critical analysis on what's necessary. And we'll do the same thing again for the 2019 aggregate production quota.
That's good. I think that's going in the right direction because, as Senator Durbin indicated, it's hard to believe that our country needs 14 billion opioid pills per year. I really don't know how you go about determining what the country needs, but the fact that we're in a crisis and that the approvals are going down, that's a good thing. I wanted to ask you about your 360 strategy for attacking the opioid crisis. And Hawaii has been relatively lucky in that we have been spared the worst of the opioid crisis, but just recently the state released an opioid initiative action plan that includes a focus on 6 areas: treatment access, prescriber education, data-informed decision-making, prevention and public education, pharmacy-based intervention, and supporting law enforcement and first responders. So with your, it sounds sort of like your 360 strategy in which you are in a number of states. So based on your experience with your 360 strategy, what are the most effective ways for states, or in fact cities, to combat the opioid epidemic? And I listed 6 things that Hawaii has come up with.
So the most important thing that our agency has been very focused on is engagement and enforcement. It's going to be necessary, especially when it comes to those who handle our registrant, those who legitimately handle controlled substances. Continue our engagement, getting out to everyone who's listening, to the community, to the public, to our registrants, and also enforcement, and that's making partnerships.
I'm running out. Oh, I've gone over time, so I wanted to ask whether they're in Hawaii. Have you worked with people in Hawaii?
Yes, I have.
Good, thank you. Thank you, Mr. Chairman.
Thank you. Now, we've had at least 2 members, Senator Kennedy and Senator Hatch, for second round. I hope we can limit it to the 5 minutes for each of you. I'll start with Senator Hatch. Because we have a second panel we got to get to and give them time too.
Well, thank you, Mr. Chairman. I'd like to start this second round by raising an issue of concern. It's come to my attention recently that there's a move afoot by trial lawyers to make Big Pharma the next big tobacco. Trial lawyers are organizing conferences across the country to discuss plans to bring multi-state class actions against drug manufacturers and distributors and turn them into villains. One recent article about this effort quoted one of the leaders of this effort as saying, quote, "The vilification of this industry has not even begun yet. This litigation will vilify them. It won't make the companies look like legitimate business people. It'll make them look like they took advantage and made billions of dollars on lots of people who died from their products," unquote. Now, it's my understanding, Mr. Chairman, that some of the most vocal opponents of the legislation we're discussing today, some of the loudest voices calling for repeal, are serving as paid consultants to these trial lawyers suing the drug industry. Now, that doesn't mean that we should discount their views, but what I don't want to have happen is for this committee to become a vehicle for trial lawyers pursuing a carefully mapped out litigation strategy. I understand these trial lawyers intend to get state attorneys general involved as well, which may explain the letter we received recently from the National Association of State Attorneys General. So let's be cognizant of some of the other things going on here. Now to my questions. I have here another chart right here. This shows DEA show cause orders over the last 9 years. That was as far back as I could get the data. Again, the vertical dotted line on that chart indicates when the Ensuring Patient Access Act passed. Now, I'd like to make 2 quick points. First, the data show that rather than declining show cause orders, actually increased after the act passed by nearly 40%. Second, DEA has issued more show cause orders this year than at any time in the last 9 years. Simply put, the Ensuring Patient Access Act has not caused any sort of slowdown in show cause orders. Now, the Ensuring Patient Access Act provided a definition for imminent danger where one didn't previously exist. let me ask you, why is it a problem for DEA to have to meet a publicly known, clearly defined standard when issuing an ISO? Isn't it appropriate for individuals and companies to know the standards they're being held to?
Senator, the new legislation, in one manner, doesn't apply to the orders to show cause. It only applies to the immediate suspension orders. As far as the orders to show cause go, that is the corrective action plan where registrants are able to come back and come back to DEA and you know, explain what their remedy is or the changes that they've made to the violations that were disclosed.
On a House hearing back in October, Neil Doherty, the head of diversion control operations at DEA, was asked whether he agreed that if Congress repealed the Ensuring Patient Access Act and, quote, didn't supplement it with something else, then the same vagueness that raised concern from a whole host of constituencies would come to bear once again, unquote. Now, Mr. Doherty replied, yes, sir, quote, yes, sir, I believe we do need a mechanism at that level with respect to that tool, unquote. Now, do you agree with Mr. Doherty that simply repealing the Ensuring Patient Access Act and not having in place any sort of definition for imminent danger, as some have advocated, is not a viable course of action?
Senator, in our collaboration, in DEA's collaboration with DOJ, we believe that a change should be made. But now what that looks like in the end, it's going to require additional conversation, sir.
Okay. Chairman Grassley invited DEA Chief Administrative Law Judge John Mulrooney to testify at this hearing. As we all know, Judge Mulrooney has written an article sharply critical of the Ensuring Patient Access Act, and this article has formed the basis of much of the criticism of the law. It's my understanding that the agency declined to allow Judge Mulrooney to testify because, quote, administrative law judges are neutral finders of fact, and administrative law judge is not in a position to testify in his official or personal capacity nor to comment on legislation, unquote. Now, my question is, how do you square this position with the fact that Judge Mulrooney has already commented very publicly on this legislation and is being quoted extensively in the media by virtue of his position within the agency? And if an administrative law judge is not in a position to comment on legislation, why is he in a position to write a law review article excoriating a law that he himself is tasked with adjudicating? These are questions that I think are legitimate questions. Did DEA authorize Judge Mulrooney to publish his article?
Sir, I'm not aware of that. I can tell you that DEA has publication review board. I'm not aware if Judge Mulrooney's publication.
What was DEA's reaction when it saw the article? Do you know?
As a whole, sir, I don't know.
Okay. Is it common practice for judges to publicly opine on merits of laws they're tasked with adjudicating? Why or why not?
Sir, it may be, but it has to, we have a process within our agency where it would be presented before the Publication Review Board, and once that approval is met, then it can happen.
Okay, Mr. Chairman, now before closing, Mr. Chairman, I ask unanimous consent to enter several documents into the record. The 2014 Pharmacist Survey, the 2 GAO reports, an op-ed by Representative Marino describing the origins of the bill, some news reports about patient access problems, the letter from the VCU professor describing troubling conduct by DEA diversion control agents, and paper copies of these 2 charts. I also ask unanimous consent to enter into the record 2 letters from patient advocacy groups explaining the need for this law, the second of which was signed by 31 organizations.
Without objection, so ordered.
Thank you, Mr. Chairman.
Senator Kennedy.
Ms. Ashley, I want to thank you for coming today.
Thank you, sir.
You're a brave American. You ought to ask whoever made you come for a pay raise. Who else is here with you today from the DEA? Could you just raise your hand? How about who else is here from the Justice Department who works with DEA? Okay, welcome to all of you. This example cited by Senator Durbin, Ms. Ashley, from Kermit, West Virginia. 9 million hydrocodone pills over 2 years sent to a single pharmacy in a town of 392 people. Were you familiar with that?
Yes, I am, sir.
That's breathtaking. The American people are watching this, and let me tell you what they're thinking, in my opinion. They don't care about the meaning of the word immediately, or imminent danger, or they're not interested in the ICO, or the DEA, or the CSA, or the NBA, or the NFL. What they want to know is how a federal agency or agencies allowed 9 million hydrocodone pills over 2 years to be sent to a single pharmacy. Not 5, not 4, not 3, but one pharmacy in a town of 392 people. That's 23,000 pills per person. That's 31 pills a day for every man, woman, and child in Kermit, West Virginia. How could you allow that to happen? You know what the people of America are thinking? They don't care how many lawyers can dance on the head of a pin. They want to know how we're allowing this to happen. They're asking, what planet did we all parachute in from? How could the DEA let this happen? You talked about all the tools you had. Were they not sharp? How could this happen? Go ahead.
Sir, I hear you, and I truly share your sentiment, and so do the men and women of DEA. I have here with me today my son. He's a senior in college, and I hold him very close. He's sitting right here.
What's his name?
His name is Omari.
Omari, welcome.
And these types of things, and when you think about, when we read the news reports of the individuals who are being harmed the most, it's that age group between 18 and 24. It breaks my heart.
Ms. Ashley, I agree with you, but how could this happen?
So I can tell you that we have processes, and since I hit the deck with my my staff, we have worked very hard to change those processes. Could we do some things better? Absolutely, sir.
We have to work hard.
Yes, sir.
This is insanity.
Yes, sir.
I heard Senator Rono say there are 14 billion pills distributed in the United States every year. There are 323 million Americans. That's 43 pills for every man, woman, and child in America.
Yes, sir, and I agree with you.
Well, tell me what we need to do to stop this.
We have to do everything possible. We have to do what we're doing today, having these conversations and developing different laws and tools that can help the DEA and all of law enforcement.
I mean no disrespect. I meant what I said. I'm so pleased you would come today, but I don't want to keep having conversations. I'd like you to have whoever makes decisions at DEA and Justice to send me a letter and say this is what we need to do to stop someone from sending 9 million hydrocodone pills over a 2-year period to a single pharmacy in a town of 392 people.
Yes, sir, I'm happy to do that. Yes, sir.
So send a copy of that letter to me too, will you please?
Yeah, I wouldn't mind having one too.
Yeah, okay. Miss Ashley, we're, at least for now, we're done with you. And you've been very brave coming here. And we know that a lot of things that aren't in your hands, you've tried to answer. Because you are the witness, you'll also maybe receive some questions in writing from us or people that aren't here today. So they should be received in at least a week, and then answer as soon as you can if you do get questions in writing. We thank you very much.
Yes, sir, and thanks, Senators, for your time today.
Yeah. Now, would the next panel come, please? And while the next panel's coming, I'm going to introduce the next panel, even though you aren't seated. Our first witness is Jan Chambers. Ms. Chambers is the president of the National Fibromyalgia and Chronic Pain Association, a not-for-profit organization. Mission is to execute advocacy programs regarding access to care, scientific research, diagnosis, and treatment for people suffering from those diseases and chronic pain. Our second witness on our panel is Attorney General Brian Frosch. He has served as the Attorney General for the state of Maryland since 2015. Through his position as Attorney General for Maryland, Mr. Frosch represents the interests of the state of Maryland in cases involving community safety, environment damage, consumer fraud, predatory business practices, and civil rights issues. Prior to his position as Maryland's Attorney General, he served in the Maryland General Assembly for 28 years, while also working as an attorney in private practice. He served 5 terms in the Maryland State Senate and 4 terms in the Maryland House of Representatives, or House of Delegates. Next, we have Dr. Carmen Catazon. Dr. Catazon is the Executive Director of the National Association of Boards of Pharmacies and Secretaries of the Association's Executive Committee. In this capacity, he is responsible for the oversight of the National Association of Board of Pharmacies delivery and quality of programs, products, and services offered by that association. He is also responsible for assisting the Executive Committee of the NABP fulfill its governance functions, and he is also a registered pharmacist. And our last witness, John M. Gray, President and CEO of Healthcare Distribution Alliance, and has held these positions since 2004. He is responsible for overseeing all operations and activities of the Healthcare Distribution Alliance, which is an organization that represents primary pharmaceutical distributors. We're going to start with you, Ms. Chambers, and go the way I introduced, from left to right, my left to right. Go ahead.
All right. Thank you, sir. Thank you, Chairman Grassley, Senator Feinstein, Senator Hatch, for allowing me as a patient representative to come and testify today, and to the distinguished members of the committee. And thank you for having this hearing. In December 2005, my world changed after hysterectomy surgery. Electrifying, shocking pain went through my body, and I hurt everywhere, curled up on the couch and practically disabled for the following 16 months. Additional health problems and multiple headaches developed. Nobody could touch me because of so much pain, and I lay with 7 or 8 pillows to support my legs and arms from touching each other, not sleeping, just waiting for the hours and the days to pass. People cannot think about anything but not moving, and you stare at something while holding on and praying that the pains will stop. I lost count of how many physicians I saw who couldn't diagnose anything wrong with me. I typed up a 2-page single-spaced list of health problems that were developing. I saw a psychologist, and doctors told me nobody can have that many things wrong with them. They told me that not all of my problems could be addressed because it would take up too much appointment time. We spent tens of thousands of dollars on doctors and tests. I could not work. My family became my caregivers, as well as taking up my share of daily life responsibilities. I felt like a burden to my family and completely understood, stigmatized, and rejected by the medical community. Every day got more painful, and I was afraid that it would never end. I kept thinking that a body cannot experience so many pains. I wanted to give up many times. Our youngest daughter was 12, and I didn't feel it was fair to leave her alone. I thought about my husband. If I die, if I take my life, he doesn't deserve to rebuild his. Those thoughts kept me focused once in a while during the suicidal depressions. Eventually, I was diagnosed and treated for fibromyalgia, positional cervical cord compression, and thyroid cancer. I was fortunate to find help. The proliferation of pill mills in Florida, Kentucky, and other states in about 2005 led the DEA to significantly increase enforcement and investigation of doctors who wrote and pharmacists who filled high numbers of opioid prescriptions. Pain patients began to report difficulty filling their prescriptions for opioid medications within a couple of years. Pharmacies began turning illegitimate patients away, asking for cash, and only giving partial fills. Patient organizations began hearing about wholesale and mid-level distributors, pharmacies, and prescribers being unsure of why they were being investigated by the DEA. Shutdowns of pharmacies and doctors' offices were happening. Patients were scared and in pain, and doctors reported that the DEA was holding meetings with prescribers to warn them about red flags and overprescribing. But doctors reported the red flags were not clearly defined and ambiguous. Doctors began requiring random and frequent urine drug tests and very confining contracts of their patients about where and when they could get their prescription filled on which days. At meetings, doctors told me they were nervous to treat patients for chronic pain because they didn't know who might be lying to them to get a prescription for opioids. They resented being defensive to protect their livelihoods and that their families were fearful of them making a mistake and going to jail. The general response for the primary doctors was to stop treating people with chronic pain. Insurance companies, including CMS, are squarely to share the blame for the skyrocketing use of prescription opioids rather than non-pharmacological treatments. Paying for an opioid, especially a generic opioid, is simply cheaper than paying for integrative health treatments. Step therapies, fail-first treatments, and similar continually set people back with serious pain and cause harm to them by increasing the symptoms of their disease, chronic pain. Doctors pointed to the ruined reputations of their colleagues under DEA investigation. 2 doctors under investigation asked me to help them find other doctors to take care of their patients. I never could. The CDC guidelines for prescribing opioids was released with great fanfare and press releases by HHS on a Tuesday in March 2016. These recommendations, not laws nor statutes, state legislatures are implementing them as if they are hard, fast, standard practice rules. This is significantly harming people who need higher doses of prescription opioids for legitimate medical reasons that are documented between a doctor and a patient, where those decisions should be made, and not at the pharmacy window, nor with insurance benefit managers. The National Pain Strategy, however, was quietly published by HHS in the Federal Register on the following Friday afternoon in March. This left little doubt in the minds of millions of patients of how much they don't matter to federal officials. Recently, a staff member in my office called 5 primary care doctors' offices in northern Utah to find a new doctor to help with chronic pain on her chest wall and a feeling of unwellness. All of them said that if she was seeking care for pain, that they were not taking new patients. Then she found a lump in her breast, and last week she had a double mastectomy for stage 2 breast cancer, which metastasized to her lymph nodes. Awareness of increasing DEA investigations caused a chilling effect on doctors willing to treat legitimate chronic pain patients. Patient access to care was significantly affected after the rescheduling of hydrocodones from Schedule 3 to 2 in October of 2014. At the end of the FDA hearing, 12 of the 29 panel members said they were concerned about the impact to chronic pain patients, and I contacted FDA Deputy Director Doug Throckmorton about monitoring the unintended consequences and impact to patients. After several months passed with no action by the federal government, our nonprofit organization sponsored a national survey, which is included in my written testimony.
Thank you very much. And now General Frosch.
Mr. Chairman, Ranking Member Feinstein, Senator Hatch, I am very grateful for the opportunity to be here today and to testify. Last month, as you know, 43 of my colleagues and I sent a letter to leaders of Congress regarding the Ensuring Patient Access and Effective Drug Enforcement Act, which I too, Senator Grassley, will just refer to as the Act. The Act has been, we believe, a step backward in our collective efforts to prevent the unlawful distribution and diversion of opioids that have contributed to our national epidemic of drug addiction and death. The DEA is a vital federal partner for all of the attorneys general across the country. It needs a complete set of tools to be effective in this struggle, and in our view, the Act handcuffs the DEA. It makes it more difficult to stop dangerous and illegal shipments of narcotics. The Act also gives additional protection to those suspected of illegal activity. It requires the DEA to evaluate corrective action plans instead of moving swiftly to suspend or revoke the registration of bad actors. The consequences of the epidemic include, as has been noted in part, in 2016, more than 2 million Americans were suffering from addiction to opioids. Since the year 2000, about 200,000 Americans have died from overdoses of prescription opioids, another 100,000 from other illicit drugs like heroin and fentanyl. It keeps getting worse. In this year, in 2017, we're projected to reach 70,000 deaths. That's as many deaths, that's more deaths than Americans killed during the entire Vietnam War, just this year. The epidemic rages on, despite clear evidence that the prescription, distribution, and manufacture of opioids in excess of medical needs is contributing to its severity. The letter from the state attorneys general put it last month in part as follows. The Act effectively strips the DEA of a mission-critical tool, namely the ability to issue an immediate suspension order against a drug manufacturer or distributor whose unlawful conduct poses an imminent danger to public health or safety. Under the Controlled Substances Act, the DEA has authority to issue immediate suspension orders where the DEA finds there is an imminent danger to public health or safety. The Act altered this standard definition by requiring a substantial likelihood of an immediate threat of death, serious bodily harm, or abuse of a controlled substance. And this language has essentially or effectively eviscerated the DEA's ability to act, drawing the standard so narrowly that, in the words of Judge Mulrooney, who has been cited often this morning, it is now, quote, all but logically impossible, end quote, for the DEA to suspend a distributor for failing to comply with the law. The Act also further constrains DEA's effectiveness by giving manufacturers and distributors a new opportunity to avoid sanctions for engaging in unlawful diversion. The new law allows a registrant to file a corrective action plan prior to an appearance for a show cause proceeding. The DEA is required to first give the manufacturer or distributor at least 30 days to prepare a corrective action plan, and then to consider that cap in determining whether enforcement proceedings should continue. In effect, it affords lawbreakers leverage to obtain additional chances, and as Judge Mulrooney points out, it is akin to mandating that law enforcement authorities allow shoplifting suspects caught in the act the opportunity to outline how they intend to replace the purloined items on store shelves. I remain mindful of the imperative that in fighting this crisis, we must be careful not to overcorrect. We must not impede patient access to prescription drugs that serve immediate and legitimate medical needs, but my colleagues and I believe that the Act from last year does not advance this important goal. It just diminishes DEA's ability to prevent unlawful opioid diversion. We face, as has been said a number of times already this morning, a public health emergency. The country's success in defeating this threat depends on all of us, state, local, federal authorities working together effectively. We're fighting a public health conflagration of epic proportions, And I believe that last year's act stands on the fire hose. I would urge you to repeal it. Thank you very much.
Thank you, General Freisch. Now, Dr. Cardozo.
Thank you, Chairman Grassley, Ranking Member Feinstein, and Senator Hatch. Thank you for the opportunity to inform the committee of our concerns about the law and the need to repeal or modify the law. I'd like to modify my comments this morning and address some of the issues which the committee members have raised. First, NABP was not one of the groups that simply jumped on the bandwagon once the Washington Post or 60 Minutes article hit. We sent our concerns and letters to Senators Grassley and Leahy back in September 5th, 2014, and in those letters we commented that the law would have a detrimental impact on the protection of public health and do irreparable damage to the enforcement ability and authority of the Drug Enforcement Administration. The ability to act decisively when an imminent danger to the public health or safety exists is critical to protecting public health. It is an enforcement action legislatively mandated to the state boards of pharmacy and utilized repeatedly and effectively by the state boards of pharmacy. The defining of imminent danger to the public health or safety by the EPA, DEA, or the law is concerning from the perspective of state regulatory agencies that successfully utilize these provisions as formally defined in the Controlled Substance Act to act with expediency and in the foremost interest of the public protection. In regard to the data which the committee has supplied in terms of the actions taken against wholesale distributors, the immediate suspension orders, and the fact that there were no orders from 2012 forward, and the fact that there was only a small percentage of orders taken against the wholesale distributor industry, from a regulatory perspective, begs the question, where was the problem? Where was the regulatory problem that mandated that the definition be changed and that there were problems with access to pharmacists, pharmacies, and patients? As a pharmacist who's in this industry and profession all the time, we heard those concerns and we saw what some of those problems were, but it did not appear to be the definitions of imminent danger that were contained in the original Controlled Substance Act and later amended by the new Act. Also, as an expert witness for the DEA and U.S. Attorney offices across the states, I can also personally attest that cases I have assisted with were unequivocal instances of egregious activities by wholesale distributors, pharmacists, and prescribers that threatened the public health and were ultimately responsible for the deaths of patients. In those cases, the access to controlled substances for legitimate medical purposes and legitimate patients were not issues and would not have been interrupted by the changes that were proposed and enacted by the Act. Fortunately, these cases represent the minority of practitioners. NABP, in unison with the states, has accredited nearly 700 wholesale distributors through our Verified Wholesale Distributor Accreditation Program. Through the VAUD program, we have come to better understand the wholesale distributor industry. Our collaborative efforts with the states and a significant number of wholesale distributors who have become accredited allow us to confidently represent that those wholesale distributors who achieve accreditation have processes in place to comply with the Controlled Substances Act and regulations and are determined to be compliant with all federal and state laws. An additional consequence of the enactment of the law is the issue of suspicious orders. Once again, in the cases I've been involved with as an expert witness, there was no question as to what constituted a suspicious order. State boards of pharmacy, many of which require the reporting of suspicious orders, consistently convey to NABP that the reporting of suspicious orders to them is simply an obfuscation of information and an attempt to bury the state boards of pharmacy in meaningless paperwork. In situations reported by the state boards of pharmacy, the reporting entity makes no effort to distinguish a legitimate suspicious order. The reporting seems to be nothing more than a statement to the boards of pharmacy saying, we've complied with the reporting of suspicious orders by reporting everything and anything. Now you can figure it out. NABP believes that this is one of the areas that needs to be modified by a change in the law. In closing, NABP appreciates the opportunity to appear for the hearing today. we offer our assistance to the committee and strongly urge the repeal or extensive modification of the Ensuring Patient Access and Effective Drug Enforcement Act. Specific language changes that we would make in response to the questions are eliminating the corrective action plan language and changing the definition of imminent danger to the public health and safety back to the original definition that is in the Controlled Substance Act formally and is utilized by all the state boards of pharmacy and has been utilized for years and years. Thank you.
Thank you, Dr. Catazone. Now, Mr. Gray. Push the red button.
Oh, I'm sorry. Yep, there we go. Good morning, Chairman Grassley, Ranking Member Feinstein. Thanks for the opportunity to come here to do this today, to talk about 483. HDA, I represent HDA, and they're the America's 35 primary wholesale drug distributors, the vital link between manufacturers, pharmacies, and healthcare providers. Our industry's primary mission is to operate the most secure and efficient supply chain in the world. As logistics experts, pharmaceutical distributors deliver all types of medicines, specialty products, chronic disease treatments, cancer medicines, and more to licensed healthcare professionals for their patients. In this effort, distributors work closely with our supply chain partners, our regulators, including DEA, FDA, and the 50 states. While the distributors do not manufacture, we don't prescribe, dispense, or drive demand for these medicines, HDA members agree with the President's recent Opioid Commission and the National Academies that addressing the drug abuse, misuse, overdose problem requires a collaboration by the entire industry stakeholders. HDA and its members are committed to being part of the solution to the crisis. We endorse a comprehensive set of policies to prevent opioid abuse and misuse, including the clinically appropriate guidelines and recommendations to curb overprescribing and improving the use of technology and data sharing. For many years, those regulated by DEA were challenged by a lack of communication and information sharing by the DEA, which I have lived through for my entire term at this association. Over the past 11 years, DEA repeatedly evolved its interpretations of suspicious order monitoring regulation, even though the regulation itself hasn't changed since 1973. Over the same period, DEA revised its views about Controlled Substances Act, requirement that manufacturers and distributors implement, quote, effective controls against diversion of particular controlled substances. And let me be clear, HDA and our members are committed to working collaboratively with DEA, and they have been, to address this issue of opioid epidemic. HDA does not wish to undermine the DEA's enforcement authority or deprive it of any of its enforcement tools. Our members have worked to comply with the DEA expectations to adjust to the challenges that accompany this opioid epidemic. Companies have invested heavily in IT systems to better flag suspicious ordering patterns and have expert teams tracking and monitoring customer orders. But HDA has also repeatedly asked the DEA to clarify its expectations by publishing some guidelines or some regulations. To develop an effective system-wide strategy, the entire supply chain must understand where the agency is coming from. And others agree. The GAO, as you've all mentioned, in June 2015 found that a lack of communication between DEA, its distributor pharmacy, and physician registrants was hampering efforts to combat the diversion problem. Even the DEA's then acting administrator, Chuck Rosenberg, told this committee last year that in his view, the agency had been slow and opaque in communicating with registrants. DEA's use of the immediate suspension order also raised concerns. As a background, entities in the pharmaceutical supply chain must have a DEA registration to handle any of these controlled substances. If DEA wants to revoke a registration, the standard process is the order to show cause, which gives the registrant full due process before revocation. The ISO is the alternative remedy and an extraordinary remedy. An ISO immediately stops the registrant from prescribing, dispensing, distributing any controlled substance medications before any due processing hearing happens. To issue an ISO, the DEA administrator must find that the registration presents, quote, an imminent danger to the public health or safety. Yet until 2016, the definition of imminent danger was left to the subjective determination of the DEA, reviewed case by a judge, only after DEA suspended the registrant. And in some cases, DEA issued ISOs claiming imminent danger based on activities that the registrants had already halted and fixed. The lack of guidance plus DEA's shifting expectations and standards generated a great uncertainty in the supply chain and had its consequences. Community pharmacists described increasingly difficulty in obtaining controlled substances affecting their legitimate patients. In 2016, Congress brought the needed clarity. In S-483, Congress defined imminent danger for the first time. Members of the Congress negotiated the law transparently with DOJ and DEA. It passed both chambers in regular order without dissent with bipartisan support, reflecting the belief the legislation offered some common sense solutions. Recent mischaracterizations have called for some to repeal the law. Notably, critics are saying the law passed in April 2016 hindered DEA's enforcement efforts in 2012 and 2013. So simply repealing the law would fail legitimate patient providers nationwide and reintroduce uncertainty into our business. The DEA remains fully empowered to take immediate action against registrant. It all retains and vigorously uses a wide range of additional tools you've heard about this morning, which range from negotiations, voluntary action, to criminal charges and forfeiture. If the law has had unintended consequences, the DEA and DOJ should bring the suggested changes to the Congress. We will gladly work with you and the administration to address and identify these concerns if need be. HDMA and my members are committed to being part of the solution to the crisis. While opioids are a small, small fraction of the medicines we do distribute every day, we're committed to collaboratively develop solutions for the challenges we face. I want to thank you all for this opportunity. It's been a long time coming, and thank you for letting me be here.
Thank you. I'm going to start with General Frosch. 43 attorneys general, including yourself, asking a letter asking for repeal of the law. That letter said the language, quote, effectively eviscerates the DEA's ability to act, and you also said that in your testimony. This first question probably doesn't take a long answer. It's the second one I would like to have more. But for the first question, do you have any data to support what you're telling us? And if not right now, would you be willing to provide that data?
Sure. Thank you, Mr. Chairman. Yes and no is the answer to do we have data. You've put up data that I think shows how infrequently ISOs are used. Okay. And with all respect, I think some of the comments are looking at it from the wrong end of the telescope. You see how few there are. I mean, even before the act, you saw that there are in the single digits for, I think it was 2011, perhaps there were 65 and dropped precipitously down to 8, 5, 9, et cetera. And what that shows you is that the ISO is used extremely infrequently. So to pass a law that makes it more difficult to use one when the actual numbers are in the low single digits doesn't really make sense. I think you have a 40-year history of the language that exists that existed in the statute before last year's act.
Maybe you could give us some examples in your state of where the law has negatively impacted your investigation.
We work closely with DEA. We just did a major case with them 2 weeks ago. We have busted pill mills and doctors who are selling prescriptions out of their cars. We don't have the authority to stop distribution. All we can do is catch it on the back end. And so it hasn't impeded our office, but it's pretty clear, I think, from the article written by Judge Mulrooney and by the paucity of cases that are brought, that the law is at best unnecessary and at worst harmful.
Okay. Mr. Gray, my first question may appear to be confrontational, but not my second and third one. Okay. In advocating for change, wasn't the industry trying to weaken DEA's enforcement authority so that your companies wouldn't be shut down in the face of ISOs?
Get used to this button. That was not my take at the time all this happened. I lived through the process of the communication shutdown with DEA when they changed hands in 2006, and I witnessed listening to our members and the groups that we put together to talk about this struggle mightily with determining various standards and algorithms for determining what is a special order, a special suspicious order, and what isn't. This went on for a number of years. Enforcement began happening. In one case, as I indicated in testimony, the problem had already been fixed, and yet the enforcement was done. And the bottom line is, it appeared, and the reality is in the minds of the people dealing with it, it appeared to our members that the goal line was constantly being shifted. And there was no steady state by which a company would look at an order and say, yeah, this is absolutely suspicious, I should report it. In fact, I can tell you anecdotally, I know one company that met with a field office.
Instead of an example, I think you just answered my second question.
Okay.
Why wasn't the previous language sufficient to provide the companies clear guidance on how to operate effectively and lawfully?
Well, the guidance was merely 2 letters, 2-page-and-a-half letters that called for the reporting of suspicious orders. There was no definitional work behind it. We then began asking, can you do some regulations around this so we have an idea of what some of these terms in this letter mean for reporting these orders. We submitted over 40 questions 3 times to the agency, never got an answer. So the bottom line is, in this period, the wholesale distributors were on their own, developing their own algorithmic systems to determine it. Some of my members had to do it by hand. Some had the resources to invest in computers and make it, more effective and quick. But the bottom line is, they did this in the blind. And the consequence was, at a time that when this opioid problem was beginning to expand, as Ms. Chambers noticed, availability of these drugs became limited because our members, the old adage, when in doubt, cut it out. When the DEA would not answer, yeah, that is or isn't a suspicious order, they would just cut off the pharmacies.
Okay, this is my last question. Can't the distributors work effectively with the DEA without limiting DEA's authority to make sure opioids don't fall into the wrong hands?
Well, we try to make that in our daily delivery, how the process moves. We try to make sure that only gets to licensed DEA pharmacies. We don't ship to anything that doesn't have a DEA license. I don't know if that answers your question, but that's the process.
Well, let me state it again. I don't think it does. Can't the distributors work effectively with the DEA without limiting DEA's authority to make sure opioids don't fall into?
Oh, absolutely. And I think we can. And I think we have. And I will tell you this, since the change at DEA, there's 2 DEAs, the DEA between 2006 and 2016 and the DEA today. I think our members would agree the working relationship has been dramatically improved. Is it because of this law or the change? I don't know. But there is definitely a more open communication line. I've had my own personal conversations. We've had our own meetings. There is clarity. I will tell you as an example, DEA put on a wonderful meeting a year ago, and a young gentleman on their legal team came in and discussed the Masters case. You may or may not know the details of that. It's not important, but what he did is he outlined for all the registrants, pharmacists, everybody in the room, and said, look, here is this case. This is what we're expecting on the appeal. If this happens, this is how DEA can use this case to enforce. That helped our members immensely to understand where the lines were being drawn. So, and that all happened within the last 24 months. So it has improved, and we're going to continue to work with them.
Senator Feinstein.
Thanks, Mr. Chairman. I'm from a medical family. My father was a general surgeon, and my husband, who passed away, a neurosurgeon. So I'm very well familiar with the term do no harm. In my view, this bill has done harm. And I look at these figures and I look at the answers that we got from the DEA, and it seems to me that we should look very closely at repeal. My question, General, is how do you view the possibility that this could really be turned into something that could be workable? There is so much money to be made and so much that has been made that it's very hard for me to see any amendments turning this around.
Thank you, Senator. I am not able to tell you what could be done to fix this. The position that I've taken, the one that my colleagues, the 43 other attorneys general, have taken, is that it ought to be repealed. We think it does. We think it does do harm. I think opioids are overprescribed and taken too often in the United States. We're 4% of the world's population. We consume 30% of the opiates, prescription opiates, and we experience 27% of the overdose deaths in the world. That's an extraordinary relationship. I mean, we're punching 8.5 times above our weight in terms of consumption and death. As everyone has noted, 14 billion pills per year for our country. It's way, way too many. And we have, of course, to strike a balance. We want to make sure that people who are suffering horrible pain get the relief they need. But we're so far in the other direction that we need not just a course correction. I mean, I believe that last year's act went in the wrong direction. Taking us back to where we were before is at least a step forward.
Thank you. Mr. Calzone, if the bill were repealed, what would the Board of Pharmacy do? What actions would you take, most likely?
Senator, if the bill was repealed, I think the states would continue to utilize the resources they have and probably provide more cases over to the DEA that they've investigated and found. And perhaps if I can comment just a little bit further.
Please. Go ahead.
There's either something wrong with the data or because simply the facts don't match. So if we have a situation where the committee and DEA are reporting that the issuance of ISOs were minimum against wholesale distributors, or none since 2012, 4 years prior to the enactment of the law, but the industry is saying that it was a device that was threatening or stopping shipments, something is not correct there. Either ISOs were being issued or not, either the industry was being affected or not impacted by it. And then the other question Senator Kennedy asked, if you ship 9 million dosage units to one pharmacy, where are the safeguards if the DEA is not able to stop that? What's the responsibility on the wholesale distributor in those cases? And that's where we think the law would need to be amended.
Well, I'm looking at this chart of ISO suspension orders from 08 to 17, and in 2011 there were 65, and I asked the question why, and it was the pill mills, and then it began to drift down. In 2014 it drifted down to single digits, and it's remained in single digits. So this, in view of what we know is out there, indicates to me that the agency isn't properly functioning because the suspension order should be way up. And I don't know whether there's interference. I know there's money to be made, interference from the pharmacy industry or anyone else. But it appears to me, based on these figures, that the law is not working. Do you agree with that, or do you find otherwise?
We agree the laws are not working.
Mr. Frosch?
Absolutely they're not working, Senator. We have so many, 200,000 deaths since 2000, the year 2000. 2 million people in our country addicted to opioids. They're clearly not working.
Mr. Gray?
Well, as far as the laws, really since 2012, 2013, that was the high watermark for the West Virginia situation as a good example. And that was a systemic failure from overprescribing. We live as a logistics group, we live in a pull system. It is pulled by the prescriber, filled by the pharmacist, and then the pharmacist orders to the wholesaler. And the wholesaler only ships to DEA licensed groups. So and all the way down to the manufacturer. There was a systemic failure of reporting. Our members, based on the lawsuits in West Virginia, did file the suspicious reports. They filed all this data with DEA, and yet there was no enforcement action. Now, at the same time, I know for a fact that our companies were working overtime on these IT systems to determine suspicious orders. And what I would argue, what's happened since 2012 and 2013, because I've heard it quiet down. The phone calls to me have quieted down. There's less and less confrontation between DEA agents, I believe, and my members, because I think my members are doing the better job now that they've self-defined for each company.
You really believe that?
Yeah, today.
With all of the pills that are out there, your members don't realize this is too many?
No, again, the DEA sets that quota. The product comes in, but we only ship so if every 50 states in the union orders this product, it's mathematically, it's high, but we ship. And we are reporting our suspicious orders. And so there haven't been enforcement actions, and there's been meetings about issues, but it's not been followed on. I think, I think as far as my 35 companies, it's trending in the right direction to get this correct.
My time is up. Thank you very much. Thank you.
Senator Hatch.
Well, thank you, Mr. Chairman and Madam Co-Chairman. I'd like to begin by thanking our witnesses for appearing here today. In particular, I'd like to thank Ms. Chambers, who is a constituent of mine, and I appreciate her coming. I think you've played an important role in bringing this issue to my attention. And you've shown a lot of courage by being here today. I really appreciate it. Let me just ask Mr. Frosch, I'd like to ask about the letter you and a number of other state attorneys general signed calling for repeal of the bill. I found the letter curious because in making the case for repeal, the letter essentially relies exclusively on Judge Mulroney's article. It cites no data or indeed anything other than Judge Mulroney's article in describing the law's impact. So my question is this: what independent analysis of the law did you and your colleagues conduct before deciding to send the letter? Evidently, you read Judge Mulroney's article. Did you do anything else?
Yes, Senator. First, let me say I found Judge Mulroney's article to be very powerful and persuasive, but there is no data since the law was passed, so we don't have that to work with. Yeah. But each one of us, all 44 of us are attorneys, and we looked at the law. And I know when you try to prove a case, when a standard changes, it's significant. And the change here is an extraordinarily high standard. When you have to prove a substantial likelihood of an immediate threat of death, serious bodily harm, or abuse of a controlled substance, it's extraordinarily difficult. And that is a very, very high standard. Sure. And any lawyer can tell you it makes a big difference. So there's no statistical analysis that I can give you, but there is a legal analysis, and it's shared by 43 other AGs. And we're evenly divided among Republicans and Democrats.
Okay, Mr. Gray, the 2015 GAO report I referenced earlier described how an absence of clear guidance from DEA to distributors regarding what constitutes a suspicious order
Correct.
and what can trigger an enforcement action was leading some distributors to decline to fill orders even when they had no evidence that a pharmacy or doctor was engaging in diversion. Can you explain to the committee how the absence of clear guidance was impacting distributors' practices and how the Insuring Patient Access Act addressed that particular problem?
I can, and I think I just want to lead off by saying, and following up with Senator Feinstein, I think the key to this law is, like any other law, we need to give it time and find out if there are issues or concerns. After 18 months, this law has not been really tested in the marketplace, and I think time will tell, and if it's appropriate, then we will go back and amend if you have to. But as far as the process it unfolded, right, I mean, our members struggled between 2007 and 2012, 2013 by numerous attempts to have meetings. I went to one of them. Mr. Ranazizi didn't attend that meeting, and that happened to be the last meeting in 2010, and we never met again with DEA. We submitted written questions, very specific questions about suspicious orders, the nature of suspicious orders, things, getting into the location of pharmacies, where are they near pain clinics, are they near state borders, and what have you. And we've submitted those questions 3 times. We still don't have any feedback from them. So our members, as I said, they went on, they had to go on their own initiative to try to define those lines. Now, you indicated they stopped supplying with no evidence. I can't speak to an individual company's decisions, but I do know many of them I spoke with would call me after their DEA meetings, quite honestly terrified, saying, look, I think they're going to pull my license. We're not sure if this stuff's suspicious. It's on the edge. Because the other problem is, when our members submit to one pharmacy a shipment of pills, we report that order, whether it's suspicious or not, to the DEA on a weekly basis. So the DEA has that. But what's not told is the DEA also has data regarding multiple other distributors, because many pharmacies are served by more than one wholesale distributor. And so and the DEA has all this so-called ARCOS data. I have asked the DEA for years, can the DEA look at us as partners in this and try to share some blinded DEA data, our full data, so you can see the full picture of a pharmacy. So my wholesaler can look at it and say, all right, well, my shipment is kind of on the edge, but if there's 3 other wholesalers also submitting, well, then that's clearly in the realm of suspicious, and we should cut them off. I have been, I've asked, I believe about 3 times formally, can we do this? Can we get together? And I keep getting answers that, we can't blind the data and this and that and the other. I never have quite believed the legal argument they like to use, but that's fine. But I sure wish, ARCOS data is a powerful tool here, and is something that hasn't come up in this hearing. But ARCOS data sharing with the wholesale distributor would help clear a lot of this problem up. I've said it for years. If the DEA sat down with my 35 members and constructively used ARCOS data, I would believe within 24 months, most of the bad players in this country could be ferreted out very, very quickly, as opposed to the gotcha game we've been playing.
I'm glad to have your testimony. We've heard a lot recently from former DEA officials expressing concerns about the Ensuring Patient Access Act and other aspects of DEA's interactions with registrants. From your perspective, has communication with DEA improved in the last 18 months since the Ensuring Patient Access Act became law?
Well, it absolutely has. With a change of personnel, I was able to open a line of communications with the head of the diversion control. We had several conversations personally at some of our meetings. The DEA has been available for our conferences. They come and speak directly to our members. And instead of bringing the old slideshow, which they showed 10 years in a row, we now have new information they're sharing with us, which I think is a huge improvement. And moreover, as I indicated earlier, and Demetra mentioned it, they'll have another stakeholder meeting this spring. We had one a year and a half ago when that young attorney from their office came in to give his musings on the Masters case and what it would mean if the DEA won that case. Well, the DEA won the case, which is great, but now my members at least have an idea what DEA is thinking in terms of where the next legal boundary is. So I think it's 100% improved in the last 18 months. I can be very complimentary of the DEA since then. It was not the case from 2006 to 2016.
Well, thank you so much.
Thank you.
Appreciate it. Thanks, Mr.
Thanks.
Thank you, Mr. Chairman. I'd like to ask the committee, and I'd like to, on behalf of all of us on the committee, thank those of you on the panel who've testified today. The ongoing opioid addiction crisis is something that has harmed every single community, has affected every state. Just my small state of Delaware lost more than 300 people who died in drug overdoses last year. And what we're trying to do is to strike the right balance between making sure that people who suffer from persistent and chronic pain, like Ms. Chambers, can get access to appropriately prescribed and managed opioids, and those who are abusing them or misusing them are appropriately held to account. And so striking that balance is the purpose of our hearing here today. and I'd appreciate a few pointed answers to some simple, hopefully pointed questions. To Attorney General Frosch. Delaware, under the leadership of our Attorney General, Matt Denn, recently enacted new regulations that allow prescribers to better monitor each opioid prescription, and that limits an adult from receiving a first-time prescription for more than 7 days, except under exceptional circumstances. So, and that's led to a 12% decrease in the number of opioid prescriptions just since April 1. Shouldn't we be looking at some of the positive, innovative work that's being done in states like Delaware?
Yes, absolutely. A number of states have prescription drug monitoring programs. They can be extraordinarily effective, despite the fact that laws like that have been enacted in Delaware and across the country. We still have this tidal wave of opioids washing across, and those are important steps forward, but we have a lot of work that remains to be done.
So help me, Attorney General Frosch, Dr. Katzion, if you would. The DEA's use of immediate suspension orders has dropped, but other enforcement tools like orders to show cause have increased. Are these other tools sufficient to combat the misuse or misprescription of opioids?
I don't think they are. I mean, and you only have to look at the results to come to that conclusion. DEA has essentially had the same tools for 4 decades, and they have not been sufficient to overcome the wave of opioids that has washed across the country. So I would say not. Now, you know, the prescription that I would give is holistic. We not only need effective law enforcement, interdiction of illegal supply, but we also need treatment. We need prescription drug monitoring. We don't have nearly enough treatment beds in our country. You know, we're not making forward progress, or we're making progress, but it's incremental. It needs to be much more rapid.
I agree with you. Dr. Katzion, what else do you think DEA should do, or what else can we do as a committee and a society to address the significant problem of opioid addiction?
I think the answer is the balance that you spoke about. We need to have a balance between access but effective law enforcement. And to the prior question, we haven't had time to analyze the data the committee presented today, but if you look at the data an overview, the DEA has taken actions in other areas to compensate for the inability or their concern about trying to take an ISO. So there has to be some balance there as well. ISOs should be restricted to the most serious, egregious cases where patients are going to be killed if that pharmacy, that distributor, that doctor continues to operate. In those cases, the standard worked. You saw by the data the amount of times the ISOs were used were very limited. So we think restoring or eliminating that data, that new standard, is a means that would quickly address the issue and give the DEA that important tool back to use that in very limited but very serious situations.
Mr. Gray, you represent distributors. There's been a lot of concerns expressed today on both sides about the Ensuring Patient Access and Effective Drug Enforcement Act. How do you think we can fix it? And how do you think we can improve and sustain that working relationship that you just talked about with the DEA to crack down on inappropriate overprescribing behavior, and to make sure that those who are genuinely in pain, like Ms. Chambers, are able to access the prescription opioids they need?
First, let me say that the DEA, I think, does agree with us. There needs to be some definition of imminent danger. If it's not the right one in the law, then we should fix it. But as I said, let time see how that works out. And it may a rush to judgment, I agree with someone on the panel alluded to, is probably not the best way to go, the most judicious way to do legislation. But that being said, I personally believe we can talk about the mechanics of law enforcement and pain management, but from a personal experience, and this just happened to me in the last 96 hours, I spent 24 hours in a major hospital here to have this shoulder bone. I now understand pain. I never understood persistent pain. Since August 3rd, I've had pain every day in my body, move in different places, from my shoulder down to my arms, and it has been miserable. 2 surgeries, the most recent last Thursday, to fix this bone for the 2nd time, and then scope out this shoulder. And in the hospital, in that 24-hour period, I was asked no less than 5 times this question as I sat down wherever I was going in. could you describe your level of pain? And I looked at these people and I said, this isn't about the pain. Pain will take care of itself. Well, you need to give me a number. What's your pain? So I began making up numbers. And then when they sent me out of the hospital after 24 hours with a prescription of oxycodone, we couldn't get it filled. My insurer wouldn't pay for it. And so it's like, well, you know, so I paid for it, and I used about 5 of them, and that's it. And I'm off it now because it's not good stuff. But it did immediately after surgery. But I, you know, it's a systemic problem beginning with the medical community, if you ask me. I'm not picking on them, but the bottom line is there has become a pattern in the medical community that pain management makes healing go faster.
Mr. Gray, let me just re-ask my last question, if I might. You concluded with what seemed an intriguing possibility, that distributors and the DEA could work more closely together to genuinely identify bad actors and to allow the continued delivery of needed pain medication to those who legitimately need it.
I have firmly held, if the DEA, you know, opened the door and said, let's work with you as a registrant, not as a criminal, as we used to be defined by someone in that agency. We were called criminals. If we worked as a registrant, I actually believe between the resources and the access of information that my members have, and then the bigger picture information DEA has, this shouldn't be a problem to identify the bad players, in my opinion.
I appreciate your testimony, but you know, as you represent those who struggle with pain chronically and daily, those who are charged with law enforcement and protecting our constituents, hundreds of whom are dying, thousands across the country, and those who are pharmacists professionally trained to dispense appropriately and distributors. We have to get this right. We have to work it out, and we need a sense of urgency about it, because there are literally people dying and people suffering needlessly. Thank you, Mr. Chairman.
Senator Hatch had one other thing he wanted to do.
No, I just want to thank you all for being here. Just wanted to thank you all for being here and for your testimony and for your help to this committee. It's been great. This is a really important subject, and we're all concerned about it. So we've learned a lot here today. Thanks so much.
Ms. Chambers, were you trying to get our attention?
Yes, sir. Chairman, I have 3 quick points. The patients really want this law. We are so grateful that it has come about, and you guys have to talk to each other. We want the DEA and the distributors and the doctors and everybody to be talking so that they know what the problems are and that they have communication about what the exact definitions are of when a distributor is in violation or what they're looking for. This hasn't happened in the past. We need this. Patients need access. My second point is that prescription opioids are only a part of the opioid issues, the illegal opioid epidemic in the United States. There's a lot more that's going on besides that. And the third is I wish Senator Kennedy was still here, because the answer to his question is that if we had the cart before the horse, if we took money and put it into pain research, we wouldn't need so many opioids. Please, I hope every member of Congress understands we don't have enough money. It's something like 6 cents per patient on pain research in America. NIH needs a pain research institute. We need to pour money into different pain treatments. Patients don't care whether or not we have opioids if we have another pain treatment. We just need pain relief, especially severe pain. Right now, that's all we have, and we are begging for help. Thank you.
Yeah, thank you, and thank all of you for your preparation and your delivery and answering questions. And remember what I said to the first panel, you may get questions over the next week for answer in writing. So staff, notify all members, get your questions in soon. If you do, we'd appreciate your response. Thank you very much. Meeting adjourned.
With House and Senate tax reform negotiations